lord.
Yes.
My lord, I beg to mention item number 3, my lord.
Yes.
This item may come up after 1 week, my lord, any day after a week.
Motion
Motion matter.
on the pair of CGI Borbia, Senate Council for the petition list after a week.
May I please remark? Lordship, with due consent from the other side, I beg to mention item number 52, my lord.
52.
Lordship, wherein I have to file my lord objection in this injunction petition, my lord.
52 is a condemnation petition, I think.
No, my lord. Injunction petition, my lord.
Injunction.
Lordship,
You have entered appearance for the
respondent opposite party.
TU Luster.
Lordship,
Inform the other side.
Lordship.
Yes, my lord.
How much time?
4 weeks time is required, my lord. I
4
am not.
weeks.
Lordship,
3 weeks.
Lordship.
TU Luster Learned Council for the respondent praised for time to file objection to DIA.
Yes.
List after 3 weeks to enable filing of such objection. Is there any interim order?
Yes, my lord.
Interim order passed early,
Yes.
extended till the next date of listing.
My lord, I think there is no stress order or.
Yes, my lord. Status code of passed earlier. Okay.
Some ad interim order perhaps would have been passed. I think it has been passed.
Yes.
Lordship,
Interim order, if any, please. If any, please. Then extended the next. Shall we fix the date?
yes, sir, subject to your lordship convenience.
Tell us. Since we are extending the interim order, it's
Lordship,
better that we fix the date.
Lord.
3 weeks we are fixing one. We'll have it on 14th of or 11th of August.
Lord.
But file your objection before
Lordship, oblige.
that. One, just this was item number 52, 11th August. Yes,
With the concern on the other side, I beg to mention item number 11.
yes,
May come after 2 weeks, lordship.
11 after 2 weeks.
Your lordship, let it come in the next week, on Wednesday.
Wednesday.
There's some urgency, very short.
Yes, what do you say?
Wednesday,
26.
26.
A prayer for adjournment has been made on behalf of the appellant. However, as Dr. Siddhan Datta, Senate Council for the respondent, has expressed some urgency. Accordingly, release this matter on
27.
27th of July.
Obliged. My lord, in respect of item number 23,
2-3.
my lord, the private respondent who is the plaintiff in the suit, my lord, I'm told that she has expired.
Okay.
And in the suit also, there is no substitution till now. So I need some instructions on this, my lord.
Okay. 3B Pathak, Senate Council for the petitioner submits that there are certain developments as there is as per his information, there is death in the case of some parties. List no, he will not, don't he accordingly praised for some time to seek instructions. List after 3 weeks.
My lord, that is.
Revenue estate. Yes.
Clear, right?
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item 55, lordship.
Yes.
Can the matter be come after 4 weeks, lordship? The talk of compromise is going on, lordship.
Here for whom?
For the petition, lordship.
Where is the other side?
We have communicated over phone,
Informed or not?
lordship.
Your name?
D. Roy on behalf of T.H. Hazarika.
D. Roy.
D. Roy.
Sri D. Roy, Senate Council, appearing on instructions of Sri T.H. Hazarika, submit that the matter may be adjourned as a talk of compromise is going on between the parties. In view of the above, list after 4 weeks.
Lordship, interim order pass earlier may
Interim order passed early, then extended till the next date of.
oblige, lordship.
Lordship, with the consent of the other side, I beg to mention item number 47.
Yes.
Here, we have filed substitution, the respondent number 8 and 9. So we need to take instruction from our.
Have you filed the substitution?
No, taking instruction from client need 4 weeks time.
8 and 9 has passed away or what?
Yes,
Your name?
C Talukdar.
You are with whom?
I'm from petitioner.
Your name is not there. Who is the senior?
S. Sharma.
Item 47.
Yes.
On the prayer of Sri C. Tarukar. No, don't like this. Sri C. Tarukar, Learned Counsel, appealing for the applicant appellant submits that there is a requirement to file substitution petition for which instructions are required, are needed. Put the para- List accordingly after 4 weeks to enable him to obtain necessary instructions and take steps. 4 weeks, yes. Other side have been informed?
Yes. Deeply obliges.
Wait, please, my lord. It's an application under section 24 of CPC for transfer of a divorce case which is pending in District and Session Judge Udalguri. And the case number is title suit in bracket D of 4/2021.
Who are you?
I'm for the petitioner,
I know, you're the husband or the wife?
wife, for the wife.
Wife is taking transfer from Udalguri to where?
Udalguri to Kamrup Metro.
What are your grounds?
She's working in a parlor in Bagharbari and she's with a minimum salary, my lord. And she has to take care of her old and ailing mother, who is
Where was the marriage solemnized?
marriage was solemnized in Udalguri, register office.
You are studying here.
Yes, my lord. I'm working in a parlor with a minimum salary, my lord. So she has to incur huge expenses to travel from Guwahati to Udalguri, so which she could not afford. my lord.
The proceeding is for divorce.
Yes, my lord. It was instituted by her husband.
Understood. Under what grounds?
Uh,
Why didn't you stay in your matrimonial place?
my lord.
Why are you staying at Guwahati when your husband is staying at Udalguri?
So, my lord, in my petition, it is mentioned that her husband forced her to work in, as she's, before her marriage, she was working in a parlor, and her husband forced her to work in after her marriage again. So she has to work here.
Now, what are the grounds of divorce which have been cited by the husband?
In page number 11, in paragraph 5,
Hmm.
of my petition, it is stated that the relationship between the petitioner and the respondent was very good for 6 months, but gradually the behavior of the respondent towards the petitioner changed. She used to rebuke by using abusive languages to the petitioner, and she used to tell abusive languages to the sister and daughter-in-law of the petitioner. The opposite party always took quarrel in some small issues with the petitioner and other family members, such as sister and daughter-in-law.
What are your grounds? Grounds of what?
Your lordship, simple, silly things he have
Those are
mentioned.
facts. What are the grounds in law? Under what provision you have, the divorce has been filed against you?
Under section 13(1) in
A.
bracket IA of Hindu Marriage Act.
What does it say? What are the grounds? When is the next date fixed? It should not be
25th
ground-
of this month.
25th is Monday.
Yes, my lord. And she has to file a return statement given as last chance, my lord.
Where are your grounds taken here in this petition?
In page number 6, my lord.
Minimum salary, mother is old. These are not sufficient grounds. Your name?
My name is C. Sharma.
Arch Christy Sharma, Senate Counsel for the petitioner who by means of this petition filed under section 24, read which section 151 of the CPC has paid for transfer of title suit within bracket D, case number, pending to to the case, to the court of the principal judge, family court, Kamrup Salem. It is the case of the petitioner, who is the wife, that are proceeding under section 13, within bracket 1, within bracket small 1 dash small a, however, of the Hindu Marriage Act 1955 has been instituted by the respondent husband at Udalguri, whereas the petitioner is presently residing at her parental home at Panjabari in the district of Kamrup and Uttar. The learned council has referred to the ground on grounds which have been cited in support of the transfer. Para issue notice returnable
Not interim maybe,
by 4 weeks. Let have be taken for service of notice upon the respondent by registered post to TD. Steps by Monday. Full stop. Para. The learned council prays for an interim order. Are you represented by any lawyer at Udalguri?
my lord, there is legal aid council.
Legal aid council is
Yes, my
there.
lord.
After hearing, this court is of the opinion that interest of justice should be served and the equity should be balanced if the proceeding in the court if the proceeding at Udalguri is stayed for the time being. Accordingly, till the returnable date, the proceeding under case number is the title should be Udalguri shall remain suspended. We give a next day to proceed. Returnable on. Wait. Returnable on 23rd of August.
Highly obliged.
23rd of August. You do one thing, you inform your legal aid council to inform their council about this order. Okay,
Highly obliged.
and take steps.
Wait, please, my lord.
Yes, what is it?
Lord, I'm preferring this present petition on being aggrieved by an order dated 24/4/2023, my lord, passed in the title suit number 63/2023, as well as in this case by the learned civil judge number 3, my lord, Kamrup Metro. Where, my lord, the facts of the matter is that the respondent herein have filed an title suit before the learned.
You are the defendant.
I'm the defendant in that particular title suit. And I have received a copy of the notice along with some documents. And I was directed to appear before the trial court on 14th of my lord, April 2023. Subsequently, I have telephonically informed my counsel to appear because I could not communicate. So morning on 14th morning, I have telephonically communicated my lord to appear asking him to appear before the court. Accordingly, a petition was being filed for filing Vakalatnama and to procure appropriate instruction from me, my lord. A date has been fixed on 24th, my lord, for filing of the Vakalatnama. On 24th, before 24th,
24th of what?
24th of April,
Same month.
same month. Upon perusal of the documents, it has come to the knowledge of my counsel that certain documents are missing in that particular bunch which has been provided to me along with the notice. So I came before the trial court and have submitted an application petition stating that certain documents are missing, and I filed Vakalatnama, and a direction was sought for supply of those particular documents, a full copy of the plaint to my lord me. But very unfortunately, rejecting that particular application, this particular order has been passed, whereby my right to file WS has been curtailed, and
Where is that order?
my lord, the 27, page number 27,
Order dated 24/4.
24/4.
What happened on the last day, 36?
Hello?
Next date was fixed on 36.
Next date on 36, my lord. Now it has been fixed on 29/8/2023 for necessary orders.
36, what had happened?
I have submitted an application before the court, my lord, that I've already preferred an application before this honorable court. So accordingly, it has been fixed on necessary orders now. In fact, 90 days does not get over on this particular date since the date of institution of this particular suit on 24/4/2023. my lord. I have procured the document from the e-court service. It was filed on 2/2/2023.
2/2/23.
I have a copy of it. If my lord wants.
Right. Where is your application? By which?
My lord, my first application, my lord will find at page number 21. This is the first application which I have filed on.
No, your application which which was rejected on 24/4/2023.
My lord, this is, my lord will find at page number 25.
25. Yes, let us read this.
May I come to this paragraph number 2, my lord? That the counsel for the defendant on the last date had appeared and sought time to file their wakalatnama and receive appropriate instruction for filing the written statement, and as such the defendant are filing their wakalatnama today.
Mr. Sensor, by this order, your right to contest by filing written statement that has not been extinguished. Your request for the documents has been rejected.
My lord, if I may take my lord to page number 27.
Yes.
The last but the second paragraph. I have perused the affidavit record further show that on last date, that is on 14/2/2023 on the petition was filed by the defendant submitting that the complete set of the document had not been received by them. In fact, in the petition bearing so and so filed on
There is
14
a line, okay. Defendants are allowed to participate in the instant suit without WS.
my lord.
And you say that on 24/4, the 90 days even was not extinguished.
My lord, since the date of institution of the suit. This is the e-court service, my lord, the document which I have procured, my lord.
But there are decisions of this court that you can obtain, there is no obligation to give all the documents.
Precisely, my lord. If I would have been given a chance to procure it, that no, I will be not providing with the document, I would have certainly got this, procured the
We
certified copy of
will
the
protect
document.
your interest so far as your right to contest by filing a WS is concerned.
My lord, my lord.
But documents we are not.
I'll procure the certified
procure
copy,
the
my lord. That is not a problem. my lord.
The next that you have said is fixed on.
It's fixed on 29/8.
But without hearing the other side, will not pass final order, still protect your interest.
My lord.
Third, Sri R. Sensor, learned counsel for the petitioner, who has preferred this, who has filed this application under section 115, read with section 151 of the CPC, along with Article 227 of the Constitution of India. Full stop. The petitioners, the petitioners are the defendants in the suit concerned. Full stop. The fact projected is that title suit number 63 of public 2023, along with Miss within bracket J case 129 of 2023, was instituted by the respondent as plaintiff in the learned court of the civil judge number 3, Kamrup, within bracket M. Full stop. As per the information received, the suit was instituted on 2/2/2023. Full stop. On receipt of information about the state suit, on 14/4/2023, the advocate of the petitioner had appeared on instruction with a prayer that formal wakalatnama would be filed and in the meantime, the copy of the plaint along with documents may be furnished. Full stop.
My lord, if I may, my lord. The documents were being furnished to me,
Okay,
but not a complete set of.
would be filed. Full stop. On the next day, fixed on 24/4/2023, it was detected that the documents accompanying the notice was not complete, and therefore a petition was filed on behalf of the petitioner to pass a direction for furnishing the complete document. Full stop. The Learned Court by the impugned order dated 24/4/2023, while where is that line in the certified copy?
my lord.
This is what it 24/4. Oh, in the title suit, it has been passed.
My lord, title suit as well as in the miscase.
No, this case, the order is different.
My petition was been rejected, it has been fixed for hearing.
No, in the miscase, the second last line is not there. It's a
My
very
lord, it is
important
not
line.
there. But my,
Understood. So we have to go to a miscase, I think. That is a more important order. Have you annexed that? Have you impugned that? You have not impugned that.
I've impugned both of them, my lord.
You have given the certified copy of the only miscase.
No, my lord, the last page, my lord. Page number 28.
Oh. Why two impugned orders of the same date while rejecting the prayer of the petitioners had also made an observation that the petitioners as defendants would be allowed to participate in the suit without written statement as per law. It is the categorical case of the petitioners that even the period of 90 days had not expired when the aforesaid order was passed, and therefore the petitioners have been deprived of a reasonable opportunity to defend their case in accordance with law. Full stop. Para, issue notice returnable on fix the date. Returnable by 4 weeks. 4 weeks. Next steps be taken for service of notice upon the respondent by registered post VTT. The learned counsel for the petitioner is also given liberty to serve copy of this petition personally to the learned counsel for the respondent on the next date fixed, which has been stated to be 29/8/2023. The learned counsel has prayed for an interim order. Sarah. Do the part of the order by which the request for furnishing documents has been rejected may not be found fault with, this court, however, is of the opinion that the observation by which the right to contest the suit without filing written statement would require some deliberation. In that view of the matter, till the returnable date, further proceedings in title suit number 2 shall remain suspended. Sarah, list this case on 21st of August. The next date is 29th.
29th, my lord.
It hardly makes any difference. Okay, we'll see. 21st of August, 2020. On the appearance of the respondent, this court would make an endeavor to dispose of this.
If I may, my lord, it can be fixed on 29th as well, so that I can serve a copy upon them, 29th August.
I will fix the date after 29th.
Okay.
Don't returnable say 6 weeks. On have it on those are holidays on 8th of September.
Hello.
Okay.
Hello.
4, 5, 6, 4, 5, 6, 4, 5, 6, 7. Okay. On 8,
Deeply obliged.
yes, what is this, Mr. Kothari?
Actually, I have come against the interim order passed by the decision session judge, my lord. That order you will also will find that at page 173, my lord. Basic facts of the case is that, my lord, what we are, a degree was obtained, my lord, expert degree.
Who are you?
I am the defendant, and the respondent in this case, my
No, in the suit.
lord.
In the suit,
Suit, my lord, I will defend.
defendant.
Now,
Suit was instituted for
no, actually, what happened, there was a decree, expert degree, my lord.
against you.
We are a plaintiff, my lord, in earlier suit in 1984, my lord.
Earlier suit, in 84, there was a suit instituted by you.
Yes, my lord, for recovery of caste position, my lord. And there was decree for caste position also, my lord. We were on pursuance of a gift deed, my lord.
Decreed in your favor.
Yes, ma'am. And subsequently, the appellate court set aside, remanded back. Then again, ex parte order was passed. They did not appear.
Against, in your favor.
Yeah, in my favor, ma'am. Then what happened, my lord, in 2023, my lord, while there was a writ of delivery of position was there in the execution case, my lord, they filed a fresh suit, my lord. Defendants.
Okay.
They filed a fresh suit, my lord. Then we filed an application for rejection of the plain, my lord. And accordingly, the court rejected the plain, my lord, on the principles of executive. Now, what has happened, my lord? Against that order, my lord, they have taken an appeal. Now, appeal was barred by limitation. When it was barred by limitation, my lord, then the session judge passed an order that limitation case will be taken up initially, then only question of admission of appeal will come. Now, in the limitation order, what the court has done, he has called for the records of all the cases there and pass an interim order, whether that is permissible or not. That's your lord. That is challenging on the side. Instead of condoning it, my lord, your lordship may kindly come to that page 172, my lord, is the initial order, my lord.
You were agreed by which order?
I will be by 3-6, my lord.
3-6. Where is this 3-6?
Yes, that is, I'm reading, my lord, 173. On 21/3/2000, Lanet Civil Judge Sibsagar disposed of miss case number 6 of 23 filed by order 7, rule
It was
11.
rejected under 711.
Rejected on
711.
21/3, my lord.
No, under order 711.
711, yes.
Okay, thereafter they filed this appeal.
Appeal, my lord. Appeal was barred by limitation, my lord. It is in this context, on failure to present the appellant to move the High Court against the order in time, file and present this case 8 of 23 under section 5 for condonation of delay. In addition, moving higher from the present place, the respondent filed KVH beforehand under section 148. Peruse the case record. Are so and so, so and so, so and so. It is a contention as well as submission of learned counsel for parties. The delay is caused in preparing the present appeal is not intentional but bona fide. As decision of miss case number so and so, so and so, and the title number 2 is still pending in the court of Lanet Municipal number 1 Sibsagar. Next date of posting is was 26/5. For posting was not supplied for further order, and on 26 SR for WS as well as pending petition number 2 and so file. Along the preparation of Gunotsav and physical inconsistency of appellant are cited the grounds for delay. These are the because they file another suit by the for the same cause of action, and that on that point they have
Okay.
opposing the contention.
Before the delay has been condoned and interim order.
Yes, my lord, whether that is permissible because see, here is they have the CPC cannot pass tax order by law.
The Court of Declarant Counsel for the petitioners who by means of this petition has put to challenge and ordered it 3/6/2023 passed by the additional district judge Sibsagar in miss case number 8 of 2023 arising out of title appeal number. Not
Two of
arising out
2000.
of, don't say arising out of, connected with title appeal number 2 of 2023. full stop. It is the case of the petitioner that in the year 1984, they had instituted a suit which was decreed in their favor And the state decree was also in their favor, full stop. In an appeal against the state decree, there was an order of remand
Remand, my lord.
which had also
On
culminated
the ground of non-joiner of parties, state of Assam was not made.
remand, which had also culminated in passing of a decree in favor of the petitioners,
Yes.
who were the plaintiff. Full stop. The state suit was put to execution, whereafter the state decree was put to execution, whereafter the present suit has been instituted against the petitioner. Full stop. The suit was dismissed on the ground of res judicata and against the state judgment, the present title appeal number 2 of 2023 has been referred before the learned court below. Full stop. The state appeal being barred by limitation, an application under section 5 of the Limitation Act has been filed, which was taken up for consideration. Full stop. Did you file objection?
Yes, we have filed a caveat, my lord.
Full stop. The learned judge by the impute ordered it 3/6/2023 while entertaining the state application under section 5 of the Limitation Act, has not only called for the entire record of the case, but has also directed that any execution process relating to suit property be stayed till the disposal of the condemnation petition. Full stop. Sarah. Sri Kotoki, the learned counsel for the petitioners has submitted that such powers to grant an interim order without the delay being condoned is without jurisdiction. Full stop. Where I issue notice returnable by 4 weeks. That step be taken for service of notice upon the respondent by registered post with 80, step by Monday. Para heard the learned counsel on the interim prayer. Full stop. After hearing and on perusal of the impugned order dated 3/6/2023, this court is of the opinion that a prior strike case is made out as apparently a court does not assume jurisdiction unless the delay involved is condoned. Accordingly, till the returnable date, the impugned order dated 3/6/2023 shall remain suspended. Since this court has passed an interim order, let a next date be fixed in this case, which is 23rd of August.
May please your lordship. My lord, the petitioner before your lordships is the plaintiff lordships. This plaintiff's husband lordships expired due to motorbike accident lordships. And during
Mr.
his-
Chaudhary, where is the, who's for the other side? We see the SP Chaudhary. Mr. SP Chaudhary is normally present with the court. Anyone? Mr. Purkashkar? Try to call him, inform. Yes, what is that? Your
Lordship-
husband had passed away in the motor vehicle
Lordships,
accident, then thereafter,
Lordships, during his lifetime, Lordships, he made an agreement with the defendant Lordships for an area of land measuring 3 10 lesses for total consideration of rupees 3,50,000.
husband was the owner of the land.
He wanted to purchase
He
the
wanted to
land.
purchase the land.
He wanted to purchase
He
the
was the
land,
prospective buyer.
Lordship, prospective buyer.
He
And-
made an agreement.
Lordship, there was an agreement, and Lordships, he was the professor also on a fixed pay, Lordships. And this motorbike accident took place, leaving behind the petitioner and 2 minor daughters, Lordships. Lordships, thereafter, Lordships, the petitioner
Hmm.
has filed a title suit, Lordships.
Hmm.
This title suit for specific performance, Lordships, and this title suit, when it was filed, at that time, Lordships, this permission was taken to deposit the port fee later on, Lordships. But it could not be due to his her financial problem, Lordships. Then, Lordship, this order, it was passed on 21/9/2012, Lordship, case 24, Lordships. Here it is, plaintiff is absent without step, peruse the record since last 2 days, plaintiff is absent without step, hence suit is dismissed for non-prosecution. Lordships, immediately thereafter, one application was filed for restoration of the suit, Lordships.
Okay.
And that order passed by the honorable court on 5/9/2013, page 30, Lordships. That petition was not considered, Lordships. It was rejected, Lordships.
Yes.
Lordships, against that, Lordships, I have approached before this honorable court, Lordships. Lordships, that already my husband invested a huge amount of money, Lordships, and I have to purchase the suit land, Lordships, and accordingly, Lordships, now I am ready to pay whatever advertisement court fee is there. At that time, Lordship, I could not pay because of my financial problems, and also I received a great shock due to my husband's death, Lordship, due to motorbike, Lordships. And here this 5/9/2013, Lordships, learned advocate for the plaintiff has filed Hajira. The instant order pertains to petition number so and so filed with the.
You are mainly against the order by which your petition for restoration has been rejected.
Rejected, Lordship. Rejected, Lordship. Lordships, now against that, Lordship, I have
But the agreement for is of the year 2010.
2010, Lordship. It is within the time, Lordship. The suit is of,
Now the agreement, the price which was there in 2010, put it with the price now.
Lordship, suit,
Is the suit property still there?
it is dear, Lordship. The suit was filed in 2012,
More than a
Lordship.
decade has passed. No third party rights have accrued.
Lordship, the suit was filed in 2012, Lordship, within the
Understood? No. From 2012 to 2023,
Lordship.
more than a decade has passed away. Now, no third party rights have accrued upon the suit land.
Still, it is dear, Lordship. The suit land is dear.
We doubt. There is no restraint order from the court. If third party rights have been has been created, there is no this entire exercise will become infructuous. Mr. Chaudhary is for the owner of the land.
Lordship.
We'll take his views. But if the suit property is intact, then only we'll think of passing some orders or entertaining this hearing you. If the suit property is not there, no point.
Lordship, I got the instruction, still that suit
Where is the suit land?
land, Lordships, it is in Harapur area, Lordships.
In the district of Kamrup.
Kamrup, Lordship, village Garal, Borua Para, Mauja Ramsarani, within Kamrup Metro.
Let Mr. Chaudhary come. Wait for a while.
Lordships.
We'll try to dispose this of. Okay. Otherwise, now we are not averse to your argument, we may have a pass an order of remand for consideration. If you give an undertaking to pay the court fee within a stipulated period of time. But if only if the suit property is intact. Let us see. Wait for a while.
Lordships.
Yes, Mr.
May it please Lordship. My Lord, this is in fact a first appeal against a part.
It is yet to be admitted.
It has already been admitted.
Then why
but
is it
Today
not for
for
admission?
its admission hearing in the previous, I'm sorry, Lordship. In the previous order, Lordship, your Lordship was pleased to just tell that it so that it can be disposed of. If your Lordship is actually going to hear it. Otherwise, it was admitted Lordship long back. Record came, so
It was not admitted.
Fellowship, the appeal arises out of a
It
decree
has
on it.
not been admitted, unfortunately.
It has not been admitted
Notice was issued.
because matter is such, your lordship.
Lordship,
Though nomenclature is.
Lordship,
appeal.
I'm just.
14/12/2022.
Oh, sorry, Lordship. That order is with me. It's for the records of court.
No, no,
And-
your assumption is correct. Normally appeal are, there is no question of issuing notice.
Hmm.
We are also certainly, but doesn't matter. And since the other parties has appeared, we can take it up for disposal of the appellate at the admission stage itself. No problem.
Lordship.
If you are agreeable, today or whenever.
Lordship, the question
Today
is,
I'm ready, Your Honor, because it was decreed on admission partly. And decree was with regard to for realization of rupees 1 crore 60 lakhs. And the records have been called for before this notice without any stay order.
according
So,
to your Lordship.
so matter may be heard and
Degree was for, on admission.
yes, decree on admission partly,
How much?
1 crore 60 lakhs.
1 crore 60 lakhs has been admitted.
Yes.
Who are you, Mr. Taluka?
Lordship, I am.
You are a
independent.
company, consultancy.
Okay.
If it is on admission, where is the scope of appeal?
Lordship, there was not that kind of admission. What has been reflected in the impugned judgment, Lordship. The matter is not that simple. Because Lordship, in fact, my company was in fact,
No, Mr. I may be correct in stating that since the records are here, the question of execution has also did not arise. When was the decree, which year, which date?
1922, Lordship.
22. Are you willing for a final disposal today? Or we can have it next week?
Lordship,
on
there
fifth?
have been so many prayers.
Hmm.
Damages are also there on the based on this. Lordship, this is one thing. Nextly, Lordship, there was no such clear admission. It should
No,
be-
no, that is it. If you are ready for a hearing, we can have it because it has to be started at one point of time. If not today, tomorrow, we cannot defer indefinitely. But today, Friday, we may not have time for a discussion today. We can have it on
Yeah, Lordship,
next
it's
Thursday.
some
Next Thursday.
next Thursday. Lordship, just a minute. It may be.
Thursday. We'll still have it at the stage of admission.
Yes.
Admitting now will again delay the procedure. Third, L. Taluka, Learned Counsel for the appellants, whereas A.K. Rai, Learned Counsel has appeared for the respondent. Do the order dated 14/12/2022 passed by this court indicate that records were called for, comma. It however appears that the appeal is yet to be admitted. Full stop. The parties, the learned counsel for the parties, however, submit that since the LCR has been received and the contesting parties are represented, comma, the appeal may be taken up for disposal at the admission stage. Full stop. Para. In view of the above, this appeal on,
27.
will have it on 27 July.
It's
Lordship, that was the first day perhaps.
Sir, it's
Lordship.
27.
deeply appeal.
May please your lordship. Here lordship, sole petitioner expired lordship. I have filed one application for substitution that is before your lordship, 3613. That is within time lordship.
3613,
Yes, sir.
13.
That is within time lordship.
Who has passed away approved that?
Yes, lordship. Petitioner. He died on 18/9/2022.
You will be replaced by 1A to 1D.
Yes, lordship, paragraph 4 lordship.
Mr. Hart. Ms. Bhattacharya for the applicant.
Petitioner
Petition. Hart, MSP Bhattacharya for the applicant petitioners who by means of this application has sought substitution in place of the original petitioner, Afruza Begum Barbhuya. Full stop. It is the case of the applicant that the original petitioner, Afruza Begum Barbhuya, of whom they are the legal heirs, had passed away on
18/9/2022.
18/9/2022,
2022. Yes, lordship.
and accordingly, this petition has been filed under Order 22, Rule 3 of the CPC for substitution. The Learned Counsel further submits that the petition has been filed within time and the right to sue subsists. Full stop. Para. The Purkas Learned Counsel for the opposite parties does not object to state prayer. And submits that he would not oppose the state prayer in principle. Full stop. In view of the above, the instant I is allowed. And the original petitioner, Afruza Begum Barbhuya, is substituted by Roman Roman 1A, 1B1, who are to be arrayed as petitioners number 1A, 1B, 1C, and 1D. I accordingly stands disposed of. In the main petition, you write, in view of the order passed today, that is in IS Civil 3613 of 2022, whereby substitution of the original petitioner, Afruza Begum Barbhuya, has been allowed, the substituted petitioners, the names of the substituted petitioners be inserted in the cause list, in the cause title. The petition may accordingly be listed after 4 weeks.
Before that, because there is no stay order lordship in this case. Date may
State may be listed thereafter.
date may be fixed if possible, lordship.
Tell us,
Any date lordship.
list as paid for, list on 11th of August.
Obliged.
Okay, we read the main petition. I hate to click to the. Yes, next.
May I please, my lord? My lord, by the impugn order. My lord, by the impugn order, the prayer for cross-examination of the witness through video conferencing was rejected, my lord. My lord, the impugn order is at page 33, my lord. Page 34, my lord.
Who are you?
I am the plaintiff, my lord.
Petitioner is the plaintiff.
Yes, I have filed a suit for divorce, my lord.
It is not plaintiff. Suit for divorce.
Divorce, my lord.
Then what had happened?
My lord, I have, thereafter, my lord.
You have appeared for the other side.
For others, yes.
We are taking for disposal of what?
Yes.
What is the stage of the suit?
My lord, it was fixed for cross-examination of the plaintiff witness, my lord.
Your cross-examination.
Yes, ma'am. No, my cross-examination is over. One of the witness.
That is it, your side.
Yes, yes. ma'am.
Your means not the plaintiff,
Yes.
but plaintiff.
PW4.
You had filed as instituted suit for divorce. You are the husband.
Yes, ma'am.
Then
My lord, thereafter
it was contested.
contested, my lord.
Thereafter,
My lord, evidence on affidavit was filed. Case was fixed for cross-examination. All other witness cross-examined. For PW4, I have filed one petition since she is residing at Guwahati along with her son, and there is no one to look after.
who is PW4?
PW4 is a witness, my lord. Her name is, my lord.
Who is she? How is she connected with you?
My lord, the suit is in the divorce suit, the basic ground is of adultery, my lord. And she is the main witness who can prove the adultery because she has provided me some photographs. She has already, there is adulterous relationship between the wife of the petitioner and my lord, her husband, my lord. And she has informed and she has provided me photograph and
The husband of PW4 is involved.
although not a party, but he is
He is involved in the,
involved. Yes, ma'am.
and she is willing to help you as a witness.
Yes, as a witness, and in the plaint, I have also stated that she has informed me and all this.
That is it. Her evidence will be needed for your support.
Yes, ma'am.
She is at Guwahati. Okay.
Yes, she is-
And she had filed her affidavit, chief in affidavit.
yes, evidence on affidavit is already filed, my lord.
Right. And now your petition was to have her cross-examination by
Video
video
conference.
conference. Where is the petition?
My lord, page 31, my lord.
Page
31.
31. Where is the suit instituted? Which court?
My lord,
Which court?
it is at Dibrugarh, my lord. Additional district judge, FTC, Dibrugarh.
Okay, page 20,
31, my lord.
31. Okay. Your name is Vikas Borgohain.
Yes, my lord.
Okay, please read.
May I read, my lord?
Yes, please read.
My lord, that the above case is fixed for cross-examination of PW4, Srimati Kritanjali Jaiswal Majumdar before the learned court, that the PW4, Srimati Kritanjali Jaiswal Majumdar is residing at Guwahati due to her service at Gijanand Chaudhary Institute of Management and Technology, Ajra, Guwahati. Further, she had a son, aged about 8 years, and there is no one to look after her child. As such, she could not appear before the learned court, that as the PW4 is unable to appear personally before the learned court to depose her evidence, as such, her evidence may be recorded.
Okay, where is the order now?
Madam, page 34, madam.
34, yes.
15/12/2022, madam. Married, madam.
Yes. Please read.
Hello?
Please read.
First one, so then today report is received from learned advocate commissioner with respect to cross-examination of PW2 and PW3. So far as PW4 is concerned, it is submitted by learned counsel for the petitioner that PW4 is residing in Guwahati and it is difficult for her to appear before this court for cross-examination. It is prayed that the cross-examination of PW4 may be conducted through video conferencing. In this regard, a petition bearing number so and so is also filed. I have heard learned counsel for the respondent as well. Considering the facts and circumstances of the case, more particularly nature of allegation of adultery, I reject the present petition bearing number so and so filed by the petitioner for cross-examination of PW4 through video conferencing. This then my lord Srimati so and so learned advocate commissioner is directed to conduct the cross-examination of the petitioner witness number 4 and file a report by the next date of hearing.
Yes.
My
Yes,
lord,
so what do you say? What are
my
your,
lord, my lord, my first submission is that, my lord, this petition filed by this petitioner is rejected only on the ground that since there is a charge of adultery, only that much, my lord, but nothing is, no such ground is assigned, my lord. And my lord, there is a video conference, or rules are there, my lord. The Guwahati High Court video conferencing rules, my lord.
okay.
My lord, here, my lord, chapter 3, my lord, it provides for procedure for video conferencing.
Madam, have a seat. Don't sit there like that.
Lord, see,
Have a seat somewhere.
my lord, chapter 3 of these rules, my lord,
Hmm.
provide a procedure. for-
Copy, have you furnished a copy?
My lord, I have not, but that is in the Guwahati High Court rules.
You have an extra copy?
No, my lord, so may come with a-
নতুন কোন?
Guwahati-
নতুন copy. Do you know the page in this
my
book?
lord, it's
I'll wait, find it out.
page number, my lord, if it is new book, page 544, my lord.
544.
Notification number 27, Lordship,
544.
dated 18th May 2020.
544.
Yes, my. Guwahati High Court video conferencing
Yes, we have got.
rules, my lord.
Appendix 44. Yes,
My lord, here, my lord, chapter 3, my lord.
chapter 3.
Rule 6, my lord.
That's up. Chapter 3 procedure.
Yes, my lord. Procedure for video conferencing.
Rule 6. Yes.
My lord, rule 6.1, my lord.
Hmm.
Any party to the proceeding or witness, save and except where proceedings are initiated at the instance of the court, may move a request for video conferencing. A party or witness seeking a video conferencing shall do so by making a request in the form prescribed in Schedule 2. 6.2, any proposal to move a request to do for video conferencing should first be discussed with the other party or parties to the proceeding, except where it is not possible or inappropriate. For example, in cases such as urgent application, 6.3, my lord, on receipt of such a request and upon hearing all concerned persons, the court will pass an appropriate order after ascertaining that the application is not filed with an intention to impede a fair trial or to delay the proceedings. My lord, this is the basic criteria for allowing or disallowing the petition. my lord. But the learned court below has not considered this aspect of the matter.
No, court has said that the allegation upon which the cross-examination would be held is an allegation of adultery.
Adultery.
And that to have a cross-examination of a witness making such an allegation, it might be an action to impede a fair trial. Delay part will not come. It's not a question of delay. In fact, the matter case will be expedited.
Yes.
But whether it be fair, whether they have the adequate chance to an opportunity to have a fair cross-examination, effective cross-examination.
My lord,
These are slightly matters in the gray area. We cannot just say that the order is per se illegal or bad in law. It depends on the discussion and what is the conduct of the parties. And the presiding officer, he who is in touch with the parties, is the best person, I think, to apply his mind. We have understood your difficulty. You're a lady working in a college. You have a son of 8 years. You are Mr.
Yes, Ahad.
Mr. Ahad, what do you say?
Lordship.
What do you see? What is your?
Yes, Lordship.
We'll come back to you.
PW4, he has already supplied all the materials for institution of the suit. He is the prime witness. And the evidence he has tendered by way of examination in chief, that is page 26, 27, 28, 29, and 30. And those were shown at Dibrugarh, before the notary. That is one of my conditions. If he can go to Dibrugarh to show affidavit in the examination in chief, then what prompted her to desist to attend the court at Dibrugarh? Now, next my submission is that what you will see, our High Court has provided a CIDIL form in rule a CIDIL 2 prescribed form, request for video conferencing.
Okay. The same rule.
Same High Court notification.
Yes.
And last page, last two pages. CIDIL 2 request for video conferencing. And this is the prescribed form by our own High Court.
Yes.
But herein, the petition was filed by the advocate concerned, and that is page 31 and 32, Annexure D, filed by
Yes.
some Dwara.
Yes.
He is the engaged advocate for the petition. Now, what are the grounds? This is stated by her that PW4 is residing at Guwahati. And due to her service at Girijananda Chaudhary Institute Management, Azara, further she had a son aged about 8 years. These are the two grounds.
Yes.
Now, the petition is verified by the advocate herself, not by the PW4, as is required in view of this prescribed format.
Now, in the prescribed format, what is required?
Yes, yes.
Signature of the applicant authorized.
No,
You're referring to Schedule 2, aren't you?
CIDIL 2, request
2.
for video conferencing.
Yes, request for video conferencing.
There are certain particulars are to be provided.
Yes, particulars. Then thereafter, I have read
No,
read and understood the provisions of the rules of so and so. I undertake to remain bound by the same to the extent applicable. I agree to pay video conference charges if directed by the court. Signature of the applicant authorized.
authorized. Besides, this is the case number, court title,
Yes.
proposed date of occurrence, location. These are the particulars to be provided before the trial court. But herein, the advocate has simply written a petition before the
We'll not be very strict with the format.
one.
We'll go by the substance. I think substance has
And
been.
thirdly,
Yes.
there is no provision, no clear provision has been provided in the rule that for cross-examination, it is a matter of cross-examination. It can be done only through video conferencing. There is no such provision. It is not yet clear from this rule. They have tendered examination in chief personally, physically attending the court and affidavit.
No, has it been restrained to only chief examination?
And she is the most material witness. Unless she comes and she is physically cross-examined.
Now, this you cannot restrain or confined to mean we give a restrictive meaning to only the chief examination. It will include cross examination because it is examination of witness.
Whatever be the other irregularities are there, they have not come in consonance with the rules. An advocate cannot file this type of petition. Request ought to have been come from the witness herself. These are my objections. So order passed by the learned trial court needs no interference. This is my.
My lord, with regard to submission of my senior friend, my lord, although she, at the time of filing her evidence and affidavit, she went to Dibrugarh, but at present she is not willing to go to Dibrugarh, my lord. That is the difficulty. And my lord, she is the main witness who can prove the charge of adultery, my lord. Lordship knows, my lord, how it is difficult to prove the charge of adultery, my lord. And my lord, that's why this petition is filed, my lord. And with regard to objection, my lord, the form and all this, the particulars are not given.
Form we may not be very inclined to accept because it is the substance. It may not be the form.
Yes, my lord.
But Mrs. Ahad has put forward a very important point that you could go all the way to Dibrugarh to swear the affidavit for chief examination, which you could have very well have done at Guwahati itself.
Yes.
Before a notary, file it there.
Yes, that is there, my lord, but that at that time she went there, but she
And the
had-
question of difficulty, which you are now trying to project, that will not, it cannot be sustained. You have the same difficulties in filing the chief examination.
that is there, my
You
lord, but
chose to go for the chief now for the cross. We are not saying that you, but it's up to the discretion of the, and these rules were incorporated at a time when you know why it was incorporated. Now the situation is also not there.
but my lord, now I don't know the physically, but what is informed by the learned from the court, advocate from the trial court, my lord. Now the evidence, some of the evidence in NIA cases and in some other cases are also recorded for the video conferencing, my lord.
No, we are not saying that video conference is not possible or should not be allowed. It can be allowed from case to case basis.
My
But
lord,
here he has cited a reason
yes,
that she being the star witness and the allegation is of adultery.
my lord,
Perhaps the cross by video conference may not be an effective
my
one.
lord, may I pray one thing, my lord, my lord, the witness can be cross-examined for the commissioner, my lord. So instead of Dibrugarh, whether I will, if required, I will file a petition, my lord, that let her be examined at Guwahati, I will pay the cost and
Who will
everything.
come to Guwahati?
My lord, if the advocate commissioner and
Oh. This is not be reasonable.
because if she cannot be cross-examined, then my lord, my whole case will fall, my lord. That's my difficulty.
Yeah, but the cross examination will be done by whom? Other side.
Other side.
If you do something at your own cost for your own benefit, then matter we can allow. So chief, you want to deduce here, it was not allowed. But cross examination, you cannot cause hardship to the other side. That will, I don't think it will be in the interest of justice or in the fairness of things. Okay. But we take Gupta, learned counsel for the petitioner. Also heard the A.S. Ahad, learned counsel for the sole respondent. The instant, have you seen it? The instant petition has been filed under Article 227 of the Constitution of India against an order dated 15/12/2022 passed by the learned additional district judge within FTC Dibrugarh entitled to D number 119 of 2019 rejecting the petition number 1436 of 2022. The aforesaid petition was filed by the petitioner, who is also the plaintiff, by which a prayer was made that the PW4 may be cross-examined through video conference. it is the case of the petitioner that the petitioner as plaintiff has filed a suit for divorce, which has been contested by the respondent wife. Full stop. In the same proceedings, witnesses, evidence in chief has been filed by way of affidavit, including the evidence of the PW4. Full stop. At the time of cross-examination, the aforesaid petition was presented to allow the examination of the PW4 by video conferencing, and the grounds cited were that the PW4 is a working woman at Guwahati and has a son of 8 years, and it would be difficult for her to present herself for cross-examination at Dibrugarh. Full stop. The learned court by the impugned order dated 15/12/2022 has, however, rejected the state petition by observing that the state PW4 by observing that adultery being a principal ground for seeking divorce, and the PW4 being the main witness to support the case of the plaintiff, her cross-examination by video conferencing may not be appropriate. Full stop. Para. Sri Gupta, the learned counsel for the petitioner, has submitted that the reasons cited may not be good reasons, as the principal issue raised in the petition was not considered at all. Full stop. He submits that there is no discussion on the difficulties expressed, namely that the PW4 was a working woman having an 8-year-old son and was residing at Guwahati, and there would be difficulty to present herself at Dibrugarh for cross-examination. Full stop. Sri Gupta has also drawn the attention of this court to the Guwahati High Court rules for video conferencing of court, which is Appendix 14 to the Guwahati High Court rule. Full stop. Referring to Chapter 6 and the rules framed thereunder, more particularly Rule 6.1, the learned counsel has submitted that such video conferencing is permitted, and therefore there was no impediment in allowing the cross-examination of the PW4 by video conference. He submits that the restrictions imposed, namely that such approach may impede a fair trial, was also not present, and therefore the impugned order dated 15/12/2022 is liable to be interfered with. Full stop. Para. Per contrast, Sri Ahad, the learned counsel for the respondent has submitted that adultery being the principal ground for seeking divorce, in which PW4 is the prime witness, comma, cross-examination of the state PW4 by video conferencing may not lead to an effective cross-examination, whereby it may not effective cross-examination. He submits that the fairness of the proceeding would also be affected if such cross-examination is done through video conference. Sri Ahad, by referring to the chief examination of the state PW4, has submitted that the affidavit was deposed. Affidavit in chief was deposed by the PW4 at Dibrugarh, and therefore the ground of difficulties now projected cannot be grounds at all. He further submits that the rules pressed into service contains Schedule 2, which mandates filing of petition in a particular format, and the state Schedule 2 has not been followed in the instant case. It is also the submission of Sri Ahad that the rules does not specifically permit examination, permits cross-examination in by way of video conference, and therefore no interference is liable to be made with the impugned order dated 15/12/2020. The rival submission made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. It is not in dispute that the principal ground urged by the petitioner in his divorce petition is a ground based on adultery. And it is also not in dispute that the PW4 would be the star witness to prove the aforesaid ground, as according to the petitioner, it is according to the petitioner, the source of information of the allegation of adultery is the PW4. This court has noticed that the PW4 had deposed our chief examination at Dibrugarh, and therefore this court finds fault in the argument of Sri Ahad, who has submitted that the ground of difficulty cannot be taken now at the stage of cross-examination, as the same situation had, as the same situation was existing when the PW4 had come to Dibrugarh. When the PW4 had made her deposition in chief and could come to Dibrugarh. More so, when such chief examination could have very well been executed by way of affidavit at Guwahati itself. This the rules pressed into service on behalf of the petitioner, no doubt makes arrangements for examination of witnesses by video conferencing. And this court may not accept the submission made on behalf of the respondent that since cross-examination by video conferencing has not been specifically mentioned, comma, such procedure is not permitted. Full stop. At the same time, however, at the same time, comma, such procedure which can be adopted would ultimately depend on the facts and circumstances of the case. Full stop. In the instant case, comma, the learned additional district judge, comma, Dibrugarh has exercised his discretion by rejecting the petition by observing that by noting that the nature of allegation was of adultery, which was the ground of the divorce, and therefore examination of PW4 by video conferencing would not be proper. Full stop. This court is of the opinion that such discretion which has been exercised by the court who has direct interaction with the parties is not liable to be interfered in a routine or light manner. And light manner, full stop. This court, as stated above, has also seen that since the chief examination was executed by way of affidavit at Dibrugarh, comma, the ground of difficulty may not be an adequate ground. Full stop. In view of the above, comma, this court is of the opinion that the present challenge with regard to the order dated 15/12/2022 is not sustainable, and accordingly, this petition is dismissed. Full stop. Consequently, comma, the interim order passed on 22/2/2023, which has been extended from time to time, stands vacated. Full stop. Since the proceedings were stayed in the meantime, comma, the petitioner may be given an opportunity to present the PW4 for cross-examination in accordance with law on a date to be fixed by the learned court. Obliged. All smiles.
That's it.
Both of us have filed against on the same judgment, right?
Both of you have?
I have filed an appeal
Appeal and cross.
on behalf of ICICI number, and he has also filed an
Appeal for the claimant
yes, sir.
for enhancement,
For enhancement rate of interest, basically.
and you are against the award.
I'm against the award on two grounds, Lord. One of the grounds relate to DL. and I could not complete the year, but I think it was heard by constitutional bench yesterday. Rambhadevi versus Bhagat. Whether a person holding a LMV can also drive
On the driving license, they
on the
checked.
driving license. I could not.
He had an
find
LMV.
LMV.
Now he was driving one.
He was driving a pickup van.
Whether pickup van would come under LMV.
Yes, LMV. So that is one
LMV
issue.
was
Lordship.
for a commercial
Maybe
purpose.
it might have been decided yesterday also, I don't know.
That LMV was for a commercial vehicle.
It was, that LMV was for a commercial pickup van, Lordship.
No. The license.
License
he
was
had,
for a, not for a transport land.
it was
for
for a
private vehicle.
private vehicle.
Yes, sir. That is
the-
one ground. The other ground is the
And the vehicle involved was a commercial vehicle.
commercial.
Okay.
That may have been decided yesterday. I could not complete the
Decided, Mr.
updates.
Lal, has it been decided?
No,
Yesterday it was had. No,
it was heard, but
yes,
not
yes.
decided. But again, we fix.
Apart from that, there is another aspect of the case.
Yeah.
The accident had occurred at 11:50 p.m. at night. And just in front of the Dispur Janta Bhavan, there is that Rotary is there, goal. There are reports, materials to suggest that he had himself rammed the vehicle into the goal, that Rotary, goal chapter. But the police report has come in the version that there's a pickup van which had slashed pushed it from the side, and then it went on to hit the ear.
Mr. Goswami, as you know, on factual part, appellate court cannot go. We'll go by the whatever facts have been.
There is another side to it.
On the law point, on the DL thing, we may.
Yeah, there is another part to it. Recently, there's a very interesting judgment by the Supreme Court on the issue of alcohol in the content of the blood. Here, one of the was evidence which was led by the company was that the
Was it proved?
no, it is not. I'm coming. That's why I have cited this
No, if it
judgment.
is not proved whether
No,
it is alcohol or not.
Lordship, in this case also, there is a three-judge bench decision, very, IFCO Tokyo Limited versus Parley Beverages.
Yes,
Lordship, the circumstances are such, in spite of any material indicating the content of percentage of alcohol in the blood, there's nothing such. Lordship. In spite of the Supreme Court, Lordship came to a year that unless the person was drunk, this kind of accident could not have occurred. That I have this decision also.
No,
Unless the person was drunk.
No, those
the
would be,
person-
those would be the facts and circumstances.
Yes, sir, that has.
Now
to-
you are taking a presumption which is against the claimant. And that presumption without
that-
there being proved.
Yeah.
And in today's context, where you know how alcohol is proved, it's not that you are assuming somebody to be drunk.
But in this case, Lordship, in the middle of the night, why would the vehicles, Lordship, roads
Mr.
are,
Goswami, those
roads are
those-
practically
those are
empty.
matters of presumption. We cannot say. Emergency may
Yes,
occur
I
at,
will argue on that point later.
emergency may occur at middle of the night, early in the morning, nobody knows. For that cannot be a fault that why was he driving at 12 o'clock.
No, it's not that. Why would another vehicle come and try to overtake in when the road is literally, we can imagine the roads to be mostly
It's an accident. As you
free
know,
of
anything can happen.
congestion, free of traffic.
Anything can happen even at 12 o'clock, 1 o'clock.
There-
Accident.
There's the postmortem reported indicated, and it sent a blood sample to the FSL, Forensic Science Laboratory. It's there in the positive, we detailed comment.
What was the outcome? Or
That was not. Raymond said neither, the member could have insisted when the
it's a
evidence was
death,
this.
it's a death case.
It's a death.
How much is the amount?
64 lakhs 35,000.
What was he doing?
He's an engineer in the government.
What
He-
is it?
Huh?
Engineer in water is department.
He was driving his
He was
vehicle
driving the vehicle.
and the pickup van had dashed him.
How the unfortunate accident happened.
What was the age?
55 years. Mature, responsible person will have such type of allegations. will have-
No, that we are not, allegations we are not doing. Unless those have come substance.
Has all the tribunal has very well dealt with. from-
You are only on the interest part.
I am basically on the interest. 6% interest was granted below if matter. So if the lordship sees the Workman Compensation Act below, it says 12% below. Why it is difference between the Workman Compensation Act and the Motor Vehicle Act below? no constitutional bench has ever deal with this, constitutional court has deal with it. Second thing, Lord, that there are,
Now, normally, what is the interest rate?
it's not fixed, Lord, that is the difficulty, Lord.
That
Sometimes
you
the
cannot
Supreme-
find fault.
Average lordship is, no.
But sometimes the court has said, Lord, then not be less than 9%, Lord. But
What is the
sometimes
banking rate? What is the banking rate of interest?
The banking rate again differs, Lord. Lending rate, banking lending rate, the rate in which the Reserve Bank of
No,
India.
not lending.
Not
Lending would be
lending,
something
bank rate
extra,
is
not rate. What is the rate where which
Well, lordship, senior citizens is maximum 7.5.
Senior
and for an FD 6 point something or 750?
something, Lord. But Lord, see one thing, Lord, if in the workman compensation.
How
Act,
many issues are there?
Only, from my side, only we are on the interest part.
No, not
Issue
Children.
one, Lord. One wife and one daughter, Lord.
one daughter. How old is the daughter?
And daughter is Lord, 30 years, Lord,
Daughter is married.
married.
LCR has come.
Elsa,
We can do one thing. LCR has come. We can do one thing. We fix for final disposal.
Yes, sir.
And in the meantime, if the DL, as you have suggested,
Yes, sir.
that
That
when-
probably might have a bearing on the.
Only submission, Lord, one is, even if the DL, the judgment is upheld in favor of my learned friend, Lord, third party rights will not get affected, Lord. That issue is not there, Lord. So in that view also they are responsible, Your Honor, the judgment acted in 2015, Lord. The judgment was passed on 7/11/2022, Lord. Till now, they have not get even a penny from 2015 to till date.
what about the, while admitting what has been decided to be paid?
No, it is not been
deposited?
admitted
Not,
yet.
it's come for admission.
We'll admit this,
Yes, sir.
we'll admit this, asked to deposit 50%.
Yes.
And we may be allowed to withdraw the same, Lord.
We'll see, let them deposit.
No, Lord, again, for that, there will be hearing, Lord, for that.
They'll not be hearing.
Lord,
The moment you receive FIDA MO,
Lord, they
mention
will be
memo.
reflected in the order also that we can be allowed to dispose the moment.
come for admission.
It's
You will
come for
admit this.
admission, Lord.
Yes, sir.
Only deposit and so we may be allowed to withdraw, Lord. Otherwise, again, it will have to be lifted,
Oh.
Lord.
Heard. Three. Mr. Goswami is in item number.
In
Eight.
both the-
Lord.
eight
No,
and-
no.
Uh,
Eight and nine.
yeah,
Eight is the appealant, Lord. In eight is the.
Both- I am the, both-
Eight,
both
appealant.
again.
In eight
Uh-huh.
is the.
Heard the R. Goswami Learned Counsel for the appellant who has preferred this appeal under 173.
Yeah.
Under section 173 of the Motor Vehicles Act 1988 against a judgment and award dated 7/11/2022 passed by the learned MACT Kamrup within bracket M in MEC case number 2151 2015 by the aforesaid award, an amount of rupees 64,35,935 slash dash with 6% interest has been granted. The learned counsel for the appellant has raised the ground of a valid driving license and also what
Lordship, drunken driving. Like.
not and drunken driving. Sarah, admit. Oh, it has already, LCR has already
Lordship,
come.
Else has been written, Lord.
instead of drunken, it may put that accident occurred because of the fault of the deceased. That was,
The real and has also attributed fault on the part of deceased in the accident, causing the accident. This court has noticed that by an order dated, where LCR called for which,
Lord, in item number 9, Lord.
in your case,
In my case.
the Sri Goswami, the learned counsel has submitted that in a connected appeal filed by the claimant for enhancement, LCR has already been called for, and the state appeal has also been listed today, along with this appeal. Full stop, para. Admit 3 A. Lal, Senate Council, has already appeared for the response numbers 1 and 2.
That's from 1 and 2.
1 and 2.
One.
Put that extra copy of the memo will be served upon him. So that steps be taken for service of notice upon response numbers 3 and 4 be taken by registered postal with agent as well as by usual process. Step by Monday. In IA, you right? Heard. Learned. I heard the Argus learned counsel for the applicant appellant who by means of this application has paid for stay of the judgment and awarded to it. It is submitted that by the impugned judgment an amount of rupees 12 with 6% award, 6% interest has been awarded. Three, Goswami, the learned counsel, submits that there are good grounds of appeal and therefore the award is required to be stayed. Full stop. On the other hand, opposing the prayer for stay, Sri Lal, the learned counsel for claimant, has submitted that the accident had occurred in the year 2015 and the award has been passed in the year 2022. Until now, no payment has been made, and even if an order of stay is passed, it should be made conditional upon payment of a certain amount from the impugned award. Considering the facts and circumstances, this court is of the opinion that the entire objective of the statute being of a beneficial nature, a blanket order of stay, an unconditional order of stay may not be justified. In view of the above, though the impugned judgment and awarded to the past by is stayed, the same is subject deposit of 50% of the awarded amount in the registry of this court, which is required to be done within a period of 60 days from today. Sri Lal, the learned counsel for the claimant, prays for a liberty to release the state amount to the claimant in the event of the amount being deposited from the same may be released to the claimant on being properly identified and upon furnishing a bond. I shall dispose of. You are also on caveat.
We are early on keyboard.
Caveat was discharged. No,
You are in the eye it was distant, I believe.
caveat. Third, KLL Planet Council for the caveat applicant, caveat who has lost this caveat in respect of judgment and orders. The caveators are the claimants in the connected MSC in the connected motor accident claim case. The caveat would be heard if even this court proposes to pass any interim order. Caveat says it has.
I'm all right.
We pass an order in his case Has it been admitted, your case?
My case has been admitted.
In MSC 2023, 223, right? Third 3A learned counsel for the appellant who submits that this appeal has been admitted by order dated 7/6/2023. Three R. Goswami, learned counsel, has entered appearance for the respondent number one. Others have appeared.
No, my lord. We have taken steps from the above.
Please, Dr. Fori, for service report upon the respondables 2 and 3. Please along with MSC case number.
235, doctor.
235.
I'm already.
We'll come back 5 minutes.
Award dated 19/12/22. My lord, here is the case, very simple case. They have suppressed the deceased age because they have not submitted during the proceeding the PAN card. Then subsequently we have got it the PAN card. PAN card, it was written as date of birth in 1961. It comes
61.
61.
And in the claim petition, what was this?
Yeah, but in the claim petition, they have submitted the post-mortem report. It shows that 45 years. So automatically, it's the multiplier comes 14. If it is a 61 years, it comes in -9. So that is the only case, madam. I have not. I'm giving this, my lord, as a PAN card, copy of PAN card.
Okay, R.C. Paul, learned counsel for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act 1988 against the judgment and award dated 1912 whereby an award of an amount of rupees 7,59,500 has been granted along with interest at the rate 7.5%. Full stop. The PAL, the learned counsel, has submitted that there was suppression on the part of the claimant in which regard disclosing the date of birth and disclosing the age of the deceased. Suppression as misrepresented. Whereby, and as a result of which, a wrong multiplier was applied, leading to higher compensation.
Yes.
Admit, call for the record that step be taken.
My lord, here is a allegation 2 and 3. We have no dispute. It was not be struck out. Owner and driver. Only for quantum.
2 and 3 should be struck.
Not necessary.
Admit, call for, at this stage, Sri Pal, the learned counsel for the appellant submit that the names of the respondents 2 and 3 be struck off as the contest would only be against the claimant respondent number 1 to compare accordingly. The names of respondent 2 and 3 are struck off from the area of party. That steps be taken by registered post with AD as well as usual process for service of notice upon the sole respondent claimant. List of I same 50%. Two months.
Within 6 weeks.
Within 2 months.
Even then, my lord, they are ready to settle also.
2 months. I dispose.
Much of it.
It would be the same of the. benefit and length road. Yes,
May I please your lordship? Lordship, we file a IA, but we will with some error. Oh, lordship, today we it shall correct.
Mr. Gogoi, what do you say?
No.
I for respondents.
I for,
I for state.
madam, what is your name?
Miss S does.
MSS does Planet Council for the appearing on behalf of the appellant. Submit that an IA has been filed in this appeal for A, which however is lying defective. He undertakes to cure the defect immediately. And therefore, and immediately. Also heard the S.R. Gogoi, Planet Council for the respondent who does not oppose in principle to the prayer for allowing the Senate Council for the applicant to correct, to rectify the defect. Accordingly, the defect said to have been filed in the IA file be rectified and the same be listed
Next week,
thereafter.
they will be fixed. Next week.
Not, we are not fixing at it. IA is not before us. Not here. Yes. Yes, Islam, what is this?
Steps were taken, my lord, but in respect of 6, 8, 9, 16 and 17, my lord, steps were taken, my lord. We are going to take the steps today itself. my lord. Respect number 6, 8, 9, 16 and 17.
Office note dated 28/6/2023 reflect that press step for respond number 6, 8, 9, 16 and 17 have not been taken full profile. Priya's Islam Planet Council submit that he may be given that he would take steps immediately for which some time may be given. That the step be taken immediately and not later by Monday next.
Right.
We're giving time till Monday because tomorrow is our Saturday, but have it on Monday. Yes, next.
Lordship,
Because Parma, what is
LCR has come here, Lordship. Matter is ready for hearing. It will be listed for hearing, Your Lordship.
Madam Begum, you have appeared.
Yes, my lord, and for respondent.
LCR has come and appeal was admitted.
Yes.
Appeal already admitted.
Dr. R. Sharma, Learned Counsel, has submitted that the appeal has admitted,
There is a stay also, Your Lordship.
LCR, appeal has been admitted, LCR has been received, and the other side, and the contesting respondent has also entered appearance through MS, entered appearance, who is represented by MS R. Begum. Please release this case for admission in its turn. For hearing in its turn.
In the month of August, last week
17
of
matter already come, we're not fixing it.
Publishment.
My lord, in this case, the 1 week time may be granted, my lord, for filing substitution petition for respect number 1.
Isn't it barred by time?
My lord, I just came to know only 3/5/23, my lord. I'm newly engaged, my lord.
The RS Chauhan. Senate Council praised for and is granted further time to file substitution petition with regard to the respondent number 1, within bracket small 1 Roman, SMT Srimati Tula Biswas. Please, after 2 weeks.
Obliged.
Yes, Sharma, what is it?
May please, your lordship. This, my lord, IA is, my lord, for combination of bill of 8 days in filing the, my lord, second appeal, my lord. My lord, as regards service, my lord, the respondent number 1 and 3, my lord, 4 and 3, my lord. 2 and 3, my lord, as far as not died, my lord. My lord, the 2 and 3, my lord, have not contested the, my lord, truth. And my lord, they are the, my lord, witnesses in the, my lord, cell deed, which is, my lord, under challenge in the suit, my lord. So they are.
It is up to you if you do want to strike out their
Yes,
name.
my lord.
It is up to you if you are the appellate.
2 and 3 may be struck.
Office note dated 2/6/2023 reflects that respondent numbers 2 and 3 are yet to be substituted by their legal heirs, as the state respondents have passed away in the meantime. We ask the learned counsel for the applicant our submission that the original respondent numbers 2 and 3 were mad witnesses, and therefore their presence or the presence of their legal heirs may not be necessary for adjudication of this appeal, and accordingly the state respondent will be struck off from the area of parties. In view of the above, the however, since the state two respondents number 2 and 3 have already expired, there is no requirement of striking their names off, and the appeal will proceed. And the appeal stands debated so far as respondents 2 and 3 are concerned. Let the appeal be listed.
My lord, the condonation is there. my lord.
Let this
Lordship may condone this delay 8 days, my lord, only. 1 and 4 as served.
we'll have it another,
My lord.
because 2 orders will be
My lord.
list this case
Next,
in the next week. 8 days you have said.
8 days, my lord.
We'll confirm the case. Is there any objection?
No, they have not yet appeared, my lord.
Other respondents have been served.
1 and 4 served. 4 respondents are there,
Next week we'll
my lord. Obliged.
you write this in the IA. Yes, next. ये देख लीजिए तो कॉटन नहीं कॉटन सुनता है ऊपर कॉटन लिखा हुआ था ना ऐसे कॉटन लिखा हुआ yes
Lordship will peruse office note dated 14/7/23, Lordship. It says unserved notice on respondent 6, received without envelope and postal remark and kept at flag X. And for AD for 2 not yet received, Lordship.
when was it said? Madam, you are appealing for
I'm appearing on behalf of respondent number 1, Lord.
one. This is with respect to 2 and 6, right?
Yes,
I think-
1, 3, 4, they are, and 5 also appearing.
Now, when was the notices dispatched?
Notices were sent. Lordship, what I am thinking, Lordship, that they may be striked out because 2 is the owner of our vehicle. We are not disputing the policy, so we are live, we are saying, but we are on the quantum. 6 is the driver of the other vehicle,
Not required.
not required, Lordship.
Okay.
Since they have mentioned.
Office
it,
note unheard. Heard. I must argue Mazumdar learned counsel for the appellant. Also heard. Your Burago, madam, what is your name?
Lordship and Dekaraja.
Your N. Dekaraja. Also heard, you're for R1.
Yes, Lordship.
Ms. N. Dekaraja for respond number 1. And your Sharma, R. Sharma. For the respond number 4. Who has appeared for 5? 5.
Lordship, 5 is served, in fact, 5, 6 processor by addressing 5 kg. 5 is served, in fact, no one is appearing, Lordship. Office note dated 28/4/22.
Office note dated 28/4/2022 reflects that response number 5 has been served. Full stop. Sarah? Further office note dated 14/7/2023. However, reflects that response number 2 and response number 6 are yet to be served. Full stop. Sarah? MS Mazumdar, the London Council for the Appellate, however, submits that the aforesaid two respondents, namely respondent number 2 and respondent number 6, may not be required for adjudication of this appeal, and accordingly, their names may be struck off. Full stop. Sarah? In view of this submission, let the name of respondent number 2 and 6 be struck off from the array of parties. Appeal has been admitted.
Yes, Lordship, already admitted, and we have
It's-
deposited 50% and
Since the appeal has been, since this appeal, which is of the year 2018, has already been admitted, this the same for hearing in its turn.
yes, because it is related to other 3 cases
To
also.
avoid any confusion, the respondent, the area, there should not be any change caused in the numbering of the respondent.
Highly obliged, Lord.
But see, ma'am, for the respondent, the appeal has already been dismissed long back. Thereafter, they filed petitions for restoration along with limitation and setting of stay. That has not been pursued by them.
Appeal was dismissed on default.
Dismissed for default.
Okay.
Subsequent notice was issued to the court. They have not been appearing. Last 10 days have been appearing alone. I don't think that I have any interest anymore in this second appeal.
None appears for the applicant on call, whereas the PK Bhagavati has learned counsel has appeared for
Last 10 days.
appeared for the
All respondents, all the
all the
respondents.
respondents. Put up. Sri Bhagavati, the learned counsel has submitted that the appeal, which is of the year 2007, was initially dismissed for default,
Lords.
whereafter the instant IA has been filed for restoration. Also, he further submitted that the order sheet would reflect that the applicant is continuously defaulting in appearance, and the same statement is supported by the orders dated 4 to defaulting in appearance. Full stop. Para. On perusal of the orders, this court has found the aforesaid submission to be substantiated on perusal of orders dated 4/2/2019, 13/2/2019, 13/3/2019, 29/4/2019, 9/11/2020, and 9/6/2023. The aforesaid non-appearance on behalf of the applicant is clearly indicative of the fact that the applicant is not at all interested to pursue this matter, which otherwise also was dismissed for default on an earlier occasion.
Lordship.
In view of the above, DI is then dismissed for default.
Lordship.
Response number 3 already entered appearance.
Yes, ma'am.
So it is to the order. It's for already appeal has been admitted. That would
The
come.
Mukta here for
I have for respondent number 6, one private respondent, madam.
all the respondents have entered appearance.
They have not appeared, madam, but have duly served, madam. You know, to kindly see order.
Service is complete.
Complete.
Heard Shri J. Ahmed, learned counsel for the appellant. The Chaudhary for
1, 2, and 3.
also heard the Chaudhary, learned counsel for the respondent numbers 1, 2, and 3. Whereas Shri Mukhtar is present for the respondent number 6. It is submitted by the parties that other respondents have also been duly served, and the matter and the appeal, which is of the year 2019, can be taken up for hearing. Please for hearing. in his turn.
Can it be in August?
The matter relates to 2013, my lord. Selection of 2013. Till date, I have not been appointed because of this. TAS cycle of this, my lord.
It may be,
There is an interim order over.
interim order is there, but Lordship may be fixed, August, September, my lord.
No, my lord. It will be August, my lord.
Normally it is,
September of which year?
this year,
We thought you would say 2024.
my lord. 20, oh yes, my lord,
24.
yeah, my lord, 24.
Please, at this stage, Pramod, the learned counsel for the respondent expresses urgency as a result of selection is involved in this appeal. Full stop, para. A result of a selection held in the year 2013
Yes.
is involved. Full stop, para. In view of the above, Pramod, registry may release this case for hearing in the first week of September, in the second week of September 2023.
All right.
First week is a holiday of 3-4 days around.
2023 or
Alright.
24, my lord.
In your case, we will give it a 24. When you say urgency, we will say 24. Twenty.
May I please,
Yes, Borbaya.
my lord, on my lord, last, my lord, 9/1/2023, my lord. This appeal was, my lord,
Admitted.
my lord, on substantial question of law, my lord.
You have entered appearance. For whom?
For Mr. D. Chaudhary,
No, respondent number.
all the respond.
They have entered appearance.
My lord,
We'll have this for hearing.
my lord.
I heard 3 AM Borbaya learned counsel for the appellant who submit that this appeal has been admitted by the order dated 9/1/2023. Your name?
PJ Das.
BJ Das.
PJ Das.
Also heard PJ Das learned counsel who has appeared on behalf of the on behalf of all the respondents. LCR is not,
My lord, LCR. Something else.
this court has noted that LCR has also been received. Please release this case for hearing. Sir. Yes,
Right.
ma'am.
May I please, sir?
Yes,
Should kindly matter may be adjourned for the day, lord.
so last occasion also you are absent. 19 matter, why review?
Yes, lord.
What review? Which order?
Impugned order dated lordship 11/4/2018, lordship. 37.
Page
37.
what is the review you are seeking? Second appeal was dismissed.
Yes.
What are your grounds? What are your grounds of review?
Lordship, petitioner was, applicant was possessing the land last 50 years, Lordship. Lordship, we have narrated the grounds in case number 4, Lordship.
None of the grounds are grounds of review. Those are grounds that you have taken in the appeal.
There are 2 and 5, Lordship. There are 2 and there are 5, Lordship. We have also narrated.
You are the defendant in the suit.
Yes, Lord.
Suit has been decreed.
Yes, Lordship. Case number 10.
Initially, the suit was dismissed.
Yes, Lordship.
It was reversed by the first appellate court. Ask your petitioner to be present on the next case. I would not like to adjourn a matter of 2019. Let to review petition. A prayer for adjournment has been made on behalf of the
MU model. Mr.
ME Motor Donor Council for the petition. None appears for the respondent. Sir, in the interest of justice, please Dr.
Bless, Lordship.
May I please, your worship? Now, there is 970 days of delay in preferring this matter regular for settlement matter. 917 days.
Notices were issued.
Yes, madam.
They have entered a
They
bid.
have-
Objected.
Yes,
You filed your objection.
yes. madam. They filed their objection.
Objection filed.
I have filed objection.
Are you serious with the objection?
My lord, they have failed to show the sufficient cause.
No, are you serious with the objection?
Yes, my lord, I am
Serious.
serious because I have already suffered so much. Because the case is pending since the year 2003 and the executing court has
How much
already.
is the delay?
917 days. madam.
What are your explanation?
My lord, these present my lord appellants, they are the legal heir, my lord. Their father is expired. my lord.
Tikendra was the father.
Yes, yes.
Yes.
My lord, he was suffering from 1998, he was suffering from my lord heart diseases. And my lord, for that, my lord, we have annexed some of the documents, my lord. He was on paralysis, my lord. So that, my lord, and this was not disclosed, that is, case was going on, my lord. So this, his wife or my lord, the children, my lord. So subsequently, my lord, when the notice came, my lord, they came to know about the case, my lord.
Notice in the execution.
Notice about the execution of the same. Then only they came to know.
You are a defendant in the suit.
Yes.
Yes.
If,
Suit was for right title and interest.
my lord,
It was decreed in favor of the plaintiff.
yes.
And you are in position.
Possession-
Land has been.
Already land has been, my lord, sold off. my lord.
Power of attorney and agreement
On
was
the
sold
power of attorney, my lord, that has been sold off to some other person.
prior to that initiation of title.
So how do they execute the decree?
That has created the problem, my lord.
Yes, sir.
If you have, if you submit that third party rights have been created, and what are you suffering?
Well, the thing is that, my lord, already land has been, my lord, disposed of to some third party.
Exactly. If
They
this-
are not before the court, my lord. So that was their knowledge, my lord. Whether they should have made a party in the case, my lord. And in our
See,
written,
you are the defendant.
my lord.
You say that the suit property has been, there's third party rights have been created by you,
My lord,
and they are not made parties.
they have not been.
Decree, there is a decree in their favor.
My lord.
Now they have to execute decree against the third party.
Yes, my lord. That is creating the problem, my lord. But there are some merits in the appeal also, my lord. Because of his, my lord, illness, my lord, he could not pursue the case properly, my lord. During the
No,
trial.
those can be grounds for considering this continuation
Appeal.
application.
Appeal, my
On merits, we are not entering into the merits. But we are just practically thinking the consequences.
lord.
Now, what is the vested right now you have to come to this court?
Because, my lord, that,
The decree will not affect you. The
Because that-
property was dispendent.
yeah,
Now somebody has purchased the property.
my lord.
And the decree execution, they will be affected. They can come up under 21, 97 or whatever, or seek leave to appeal. But how are you affected?
Because that execution case is, my lord, pending against us, my lord.
What is to be executed from it? Nothing.
For execution of the decree, my
Decree,
lord.
how
we
will
are
it be
also
affected?
before the executing court, my lord.
The property has gone to somebody else by registered sale.
Possession to-
And that position has also been given to third party. Now they have to recover position from third party. They can do it, execute the decree against them, but they have the right to come under 21 to 97.
We have not told them. They got a decree.
I think this will be mere academic, I think. Let us see where are your ground.
My- There are three of the misses, my lord.
Assumptive view.
My lord, there are three of the IA, my lord. IA of our case, my lord, 1126.
Public 16, this is a degree.
1-1.
1126.
Not what is 4062?
One.
What is 4062?
Legal particular court order which we are application for.
Nothing, my lord, as regards, my lord, making the legal representative as the parties, my lord.
You have said paragraph?
Paragraph 3 of, my lord, our IA 1126. Delay condonation petition.
Yes, for paragraph 3.
That- Paragraph 3, my lord. Page number 2.
Yes, please.
That the petitioner beg to state that Tikendranath Kakoti, the predecessors in interest of petitioner was suffering from TBA with right side combative hypertension since 1998. And for his treatment, that Tikendranath Kakoti, the so-and-so petitioner was to remain in hospital for the long period. Due to the said disease, he was mostly remained bedridden. Then, my lord, we have annexed documents, my lord. Then, my lord, that late Tikendranath Kakoti could not follow up the steps in the state put by appearing physically and also relied upon the advice of his
This
advocate,
suit had proceeded ex parte over.
my lord,
Suit proceeded ex parte against your predecessor.
my lord.
It was an ex parte decree.
It is not correct. Ganga Kakoti contested this truth.
They had filed written
He
statement.
has filed written statement. He has cross-examined my witness and hereafter he ceased to appear in the court. So they have wrongly stated that the suit is being prosecuted.
From our side, defense.
They have filed their written statement.
We have filed written statement, but from our side, no, the defense witnesses could be examined.
No, non-appearance of adjournment, several adjournment taken by approved. W was closed. Several adjournments taken by defendant advocate, so TW was closed. TW closed, TW closed several adjournments. My advocate adjournment was TW, the third second closed. Argument is failed. Order to action, order.
917 days.
Yes, ma'am.
Mr. Sharma will impose some cost, will condone the delay. Will impose cost.
My lord, cost is not sufficient because their petition is not at all maintainable. My first submission before your lordship. Yes,
There is a leave application also.
yes,
We have seen that they are not the
why
original
their
party.
petition is not maintainable, I am stating this. my lord. The petitioners are Daisy Kakoti,
Leave application.
Bornali Kakoti,
Hmm.
Parat Kumar Kakoti,
Hmm.
and
Okay.
Pranodika. So in the last affidavit, we have again filed an affidavit against their petition. And they have also filed another affidavit against our affidavit. So in their affidavit, they have stated that Daisy Kakoti has been suffering from abnormality. Secondly, Bornali Kakoti, who is the eldest daughter, has also been suffering from lunacy. So whether a lunatic person or abnormal person can file a suit, this is a petition. Of course, this petition is filed under section 141 of the CP. So the provisions of
No,
all
we will
the-
not go into those aspects of the matter. We are only on the constituency delay condemnation.
but the thing is this, their petition must be maintainable one.
That,
Since
that,
this
that,
petition is
that,
filed by,
that aspect, we are not making any observation. We may consider your submission at the time of, at the appropriate stage, but we are at the stage of consideration of the delay condemnation. Only on that. If you want to make some submission, you can, we can make.
no, my lord,
Maintainability will be, will definitely
My-
consider.
where is that? I have already suffered too much. They have made agreement with me in the year 2003.
Mr. Sharma,
And
you are
they
going,
did
you are
not-
going into the merits of the case,
No.
only on the delay part.
Regarding
There
delay
the
part,
causes shown for
we-
delay.
they have not properly explained the,
Third 3 PM to the Senate Council for the applicant who by means of this petition filed under section 5 of the Limitation Act has paid for condonation of delay of 917 days in preferring the appeal against the judgment and decree dated 2012 Beast Borough in PS number 87 of 2016 by the learned civil judge number 1 at Mahan. The Chaudhary has referred to the averment made in paragraph 3, 4, 5 and 6 of the petition and has submitted that there were sufficient reasons which were beyond the control of the applicant and therefore the delay has occurred. Per contra, comma,
no,
Mr.
my
Sharma,
lord, in this respect, I need to submit one thing. They have submitted a certificate in the year of 1998. And he has not been admitted in the hospital. Secondly, this food has been.
Let us pass the order. This is only a relay condemnation. Our approach is slightly lenient. Per contrast, B.K. Sharma, then counsel for the sole respondent has strenuously opposed the prayer for condemnation of delay and has also raised the point of maintainability of the present appeal. He has submitted that the grounds cited are not sufficient grounds, and the respondent has already suffered a lot in this case. Sri Sharma further submits that there, even on merit, there is hardly any material in favor of the applicant, and therefore the instant petition be dismissed. After hearing of the parties and on perusal of the grounds cited in support of the prayer for condemnation of delay, and also taking into consideration the settled law that in matters of this nature, a pragmatic and justice-oriented approach is required to be taken, this court is of the view that interest of justice would be served if the delay of 270 days, 970 days in filing the appeal is condoned. However, considering the facts and circumstances of the case, and also the fact that the title suit is of the year 2016, 16, and the judgment and decree is of the year 2012, the purported delay of 970 days is condoned, subject to payment of cost of rupees 2,000 by the applicant. I accordingly dispose of. Yes.
Lordships, I am ready to deposit the court fee before the Honorable Trial Court, Lordships. A direction may please be issued by setting aside the order.
Yes, what do you say? Where is Mr. Chaudhary?
Lordship, today he is having some personal difficulty, so he could not come, Lordship. I am appearing on his behalf. And my submission is that, Lordship, the impugn order which they have challenged herein, it's an appealable order, Lordship, under Order 43, Rule 1. So CRP is not maintainable in this case.
What is the order?
Order 43,
No,
Rule
what is
1.
the order which is in support to challenge? Order passed under what?
Order passed under Order 9, Rule 9, Lordship.
That's an
The
applicable order.
Annexure 4, page number 30.
It is an applicable order.
Lordships, this is CRP IO, Lordships, and I have filed the application under 227, Lordship.
No, when appeal is there, how can you go for a revision? When the statute provides an appeal, Madam is right.
Yes, Lordship. Order 43, Rule 1, Clause C, it has been specifically mentioned.
Lordships, Order 43, Lordships.
Yes.
But this is lordship interlocutory order, lordships.
What interlocutory? This is dismissed for default.
Yes, sir.
Dismissed for default.
It's an interlocutory order. What is the nature of the order? Is the suit alive? Which provision are you referring?
Lordship Order 43, Rule 1, Clause C. An order under Rule 9 of Order 9 rejecting an application for an order to set aside the dismissal of a suit. And they had filed this petition to set aside the dismissal order, which was, the suit was dismissed for non-prosecution, Lordship, and
But
accordingly,
this is not an order of rejection. This is an order of dismissal for non-prosecution.
non-prosecution, Lordship, and later on they had filed one petition to restore that suit. And in that petition, this order has been passed, rejecting that prayer, Lord.
Rejecting on what? Rejecting for non-prosecution, isn't it?
Yes, Lord.
That is not a rejection on merit. 5/9/2013 is the impugned order, isn't it?
Yes, yes, Lord. 5/9
This
to
order of rejection is not on merit. An order passed under Order 9, Rule 9, rejecting an application for setting aside ex parte, that is appealable. No doubt this was an application under Order 9, Rule 9,
Yes, sir.
but it has not been rejected on merit. Into the order.
But Lordship, they had filed this petition to restore that suit, which was dismissed, Lordship, and accordingly it was again rejected.
We'll have this another day. We'll consider your point. Ask Mr. Chaudhary to be here.
Lordship.
3 hours of counsel for the petitioner. Also heard, yes,
BW, Lordship. on
BJP who submit that her tenure to SP Chaudhary could not be present due to some personal difficulties. He, however, raises an objection towards the maintainability of the PR put there. Considering the above, registry is directed to release this matter on Wednesday next.
Lordship. Oblate.
Okay, okay. Twenty-four.
In this case, my lord, actually SP Chaudhary, he appeared for the sole respondent. If lordship kindly say IA.
Yes, yes, DB.
Name has not been reflected in the cause list, Lordship.
Leave it Wednesday next. His name.
Then maybe
Your name is also not there. Ahmed.
I am the appellant, J.O. Ahmed. Second.
JU is not you. Heard J. Ahmed, counsel for the appellant who submit that though the sole respondent is represented by a counsel, namely Sri SP Chaudhary, his name has not been reflected in the cause. Full stop. Registry to release this case again on Wednesday next. Submitted by reflecting the name of Sri SP Chaudhary and a counsel for the respondent.
Oblate. May I please your lordship?
Yes.
Respondent number 1 and respondent number 2 were duly served their notice and they have responded. The respondent 3
Yeah.
was served the notice and it was received by his mother.
1 and 2, who's 1 and 2?
I am appearing for respondent number 2.
I'm for respondent number 1.
Else you are not received.
Else you are not received.
Appeal has been admitted. Has the appeal been admitted?
Yes, sir.
Appeal has been- Your name, madam?
M. Chettiar.
I'm a Chettiar, Learned Counsel. Appearing for the appeal and submit that the appeal has been admitted by the order dated 10/9/2021. And steps were directed to be taken, which was accordingly done. Full stop. Your name, one, who you are for one,
I am for 2.
I'm for 1.
your name,
P. Burwa.
MSP Burwa. Learned Counsel has entered appearance for respondent number 1 and 3,
Can I conduct? Can I?
and I can has appeared for the respondent number 2. Full stop. There is an office note dated 19/6/2023, as per which the notice issued to the respondent number 3 has been received by his mother. Full stop. The service is accordingly held to be complete. So, Sarah, call for the LCR. Whereafter the matter will be set for orders.
May I please, Lordship?
Yes, yes.
Lordship, here the parties are almost last 20 years in litigations. Now today, Lordship has to dispose of the condonation petition and the delay is 2,475 days, my lord. Inordinate delay, my lord, no doubt. And Lordship, there are certain justifications we would like to place before Lordship. And
RSA, 2000 days.
my lord, factual aspects, my lord, little bit demands that we have filed this RSA later on.
Your friend is opposing or
Yes, they are opposing.
opposing?
They are strictly opposing. Now, Lordship, may I place the facts in nutshell, my lord, so that
You want the IA to be disposed of?
my lord.
Yes.
No, Lordship, the story starts from 2004, my lord. Here, my lord, what happened that 2004, my lord, a suit was instituted 96/2004 against me.
2004 suit.
A suit was instituted against me, challenging inter alia that so far my identity as being adopted son of one of the brother of the plaintiff was put under challenge. Now here, my lord, we have filed our written statement. And after filing written statement, they have also adduced evidence, but we failed to file, my lord, DWs, my lord. And under that circumstances, my lord, a judgment was pronounced.
Yes.
That judgment was pronounced on 3/3/2011, my lord.
Yes.
Afterward, my lord, we statutory appeal filed under order 41. And that appeal was also disposed of on 30/4/2020 at 13 against me. 30/4/2013,
Your appeal dismissed.
my lord. My lord, pursuant to that appeal, we again prefer a review. And that review was again dismissed on 31/3/2016. Afterward, my lord, what happened? On the basis of the
In the
advice,
suit, it was decreed in your against you.
Man.
Your adoption was held to be illegal.
thereafter, my lord, we have preferred revision petition before this honorable court.
Revision against,
My lord, that appeal come review.
revision against the review dismissal.
My lord,
You do not file any for a second appeal.
No, my lord, that is the ultimate problem, my lord. We'll explain, my lord. Now that CRP, my lord, was also disposed of on 18/12/2018 on the basis of withdrawal made by the Learned Council, my lord. Prayer made by the Learned Council.
Now, against review dismissal, you file revision.
That was disposed of on 18/12/2018 on the strength of our prayer.
Which you withdrew.
Withdrawal.
Yes.
Now afterward, my lord, what happened? The matter was sitting silent, my lord. Now 2021 and another round of, my lord, development took place. What happened? That so far my adoption certificate is concerned, out of which I have sought a next to kin certificate. That next to kin certificate, they have objected before the Learned, my lord, deputy commissioner. And they had issued out the notice and also cancelled their own. Now that point of time, my lord, the petitioner discussed the whole issue with new set of counsel, my lord. While this new discussion was made, my lord, it was suggested that a statutory second appeal has to be filed. And based on that, my lord, 2021, the second appeal, this is RSA was filed before, has been filed before this honorable court. Now, lordship, there are two compartments, my lord, of delay. First is, my lord, kindly see from review to CRP, my lord. 2016 to 2018, this is one compartment, my lord. Article 14 will come into, section 14 will come into play, my lord.
Why?
My lord, because that my matter was under litigation, wrong forum.
Wrong forum. Why is it the wrong forum?
My
Is
lord,
review a wrong forum?
my lord, second appeal was not preferred, my lord.
Is review a wrong forum?
Review come appeal.
14 will come when you go in a wrong, in a litigation in a wrong forum without
Right.
jurisdiction.
My lord.
14 will not have an applicability generally. It's a
Quite right.
conditional applicability.
Quite right. But lordship, my submission is that we ought to have preferred something else, but it was wrongly.
No, it was open for review. It is not a case that appeal was preferred, you had gone for revision.
My lord.
You chose to go for a review, which is permissible in law.
After review, my lord, still CRP, my lord, two years, my lord. I'm just making lordship because, my
This
lord,
is not a wrong forum. 14 benefit you may not get.
no, not review, my lord. I'm CRP, my lord. That's CRP, my lord.
No, against review, CRP is maintainable.
My lord, because appeal, my lord, that has been consolidated with, my lord, appeal, my lord. Therefore, my lord,
Now, we drew the CRP on your
my
own
lord,
volition.
my lord,
Withdrawal was on 2018,
my lord, but
and this has been
my lord,
instituted in
my lord,
21.
my lord, we have filed an appeal. We have filed the revision petition. That is, my lord, against the, my lord, first appeal, my lord. Revision was filed against the first appeal along with review, my lord, order. That has been merged, my lord.
No, you said that on 31/3/2016, the review was dismissed,
Exactly, my lord.
and your revision in this court was against which order?
Against, my lord, appeal, first appeal, which has been merged with
Against
the,
34/2013.
yes, my lord.
Let us see.
Because, my lord, that
Let us see the revision.
review order, my lord.
No, the revision.
Your Lordship, there was a delay in the review, filing the review also, T93 days. This application for condemnation delay was rejected
Lordship, can you say?
In review.
in review.
Doesn't matter, it amounts to
File CRP. So
CRP for what?
against that, Lordship,
Against review only,
Against
not
review
appeal.
not appeal.
But, my lord, otherwise, my, it has been merged, my lord. Normally, my lord, that once a review has been dismissed, my lord, or allowed, my lord, ultimately it effects of
It merges with what?
with first, my lord,
The review, dismissal of the review on the ground of limitation would ultimately amount to a dismissal on merits.
my
You preferred revision against that order,
lord,
not against the order of 2013.
my lord,
Had
no,
it
my-
been or revision against 2013, which is not permissible, which is not allowed by law, since
My-
the appeal is provided, then
Right.
your 14 may come in.
my lord,
It may be a wrong forum.
Right.
Neither a review is a wrong forum, nor a revision against an order of dismissal of review is a wrong forum.
my lord, the lordship made a view, if I'm not, my lord, wrong, that against the review, revision is maintainable.
Yes.
Lordship views that. Lordship, kindly see that second facet is also very important. A review is not independent identity, normally, my lord. It has been merged with the main appeal, my lord. Now, whatever challenge,
No, no, it is a matter of fact, we can ascertain.
my lord,
Your revision was pertaining to the review order or to the first appellate court order.
my lord, yes, my lord, that is a pertinent question, my lord, because my lord, that point, my lord, I have to clarify, my lord. Because earlier that has been dealt by some other council.
Forecast, where is the order of revision dismissal?
My lord, that
Or-
content, yes, my-
82, Lordship. This is withdrawal, page 82.
Is there any details why the revision was? filed?
No, it is not, I have seen, it is not,
Is there, do you have a copy of the revision?
no, Lordship, revision petition I do not know.
Now, what is the delay? 2000 days.
my lord.
What
My
is your
lord,
explanation?
My explanation, my lord, basically, my lord, we have netted the ground on two fold, my lord. First, we have narrated that after 2018, because no any suggestion was given that at the stage of withdrawal, we could have preferred a second appeal. That set of council didn't respond us on that point, my lord. The matter only brought to the notice of the petitioner once in 2021, the matter was discussed with the new set of council, my lord. So therefore, my lord, we have taken the basic plea that due to the lack of legal knowledge about filing of second appeal, my lord, the petitioner deprived from or debarred from filing this instant revision second appeal, my lord. That is the basic ground, my lord. And prior to that, my lord, the matter was under litigation before this to that from, my lord, either review or, my lord, revision before this honorable forum. Now, lordship, this is the main ground. Now, other side has objected, and they have said in one point very
How many
important,
days delay?
by 2,475 days. We have counted from the date of, my lord, review order.
From the review order.
Yes, review order, my lord. Counted from review order, my lord. Lordship, this position actually required to clarify, my lord, that whether this revision was preferred against the review either or, my lord.
Now, even if we give the benefit to your 14,
Lordship.
let us see.
My lord.
Yes.
Now,
For a timing, let us assume that you get the benefit of 14.
now, lordship, the other side basically objected. One thing is very important because we have pleaded that since no legal advice was rendered to us, so therefore we deprived from getting the knowledge about, and they said that at the time of cross-examination that has been taken place at the stage of review application, we have uttered or we have mentioned about the part of second appeal, my lord. But, my lord, that mention is imparted to, my lord, review proceeding, my lord. But that has gone away thereafter revision was filed on the basis of the advice tendered by the, my lord, learned council. So therefore, this has no effect. Now, lord, see, statement, my lord, I am coming to the legal point that whether my ground will stand or not, my lord, in the light of the citations of this honorable court. Now, lordship, I'd like to rely upon a judgment rendered by your lordship in Usha Roy's case, the ground which has been set down and which has otherwise hold the field. Lordship, paragraph 18. If suppose I comply with this 5 condition, my lord, I have a good case. Paragraph 18, my lord, page 7. Now, lordship, set down certain guidelines. May I read, my lord?
Yes.
Paragraph 18. On a reading of the case laws governing the field, the following principle, not exhaustive, can be taken as a guidelines for deciding a petition for setting aside abatement as well as for condonation of delay. Number 1. The power vested upon a court to exercise justifications is jurisdiction is essentially a discretionary one. The natural corollary is that there has to be an application of a judicious mind by taking into consideration all the relevant factors. Number two, the relevant factors which are required to be taken into consideration would include the conduct of the party, as discretion can be exercised only by balancing the equity. Three, the length, duration of delay and explanation put forward are both relevant consideration for exercise discretion. Four, the court would generally proceed with a liberal, pragmatic and justice-oriented approach with such petition as substantial justice should not be allowed to be defeated by the mere technicality. Five, at the same time, the court would also not lose sight of the fact that a valuable right has accrued on the other party and such right should not be interfered with lightly. Therefore, though there may not be a requirement to seek a day-to-day explanation, the explanation for the delay should be a reasonable one and which is acceptable to the men of ordinary prudence. Lordship state, I am coming to the first column. Here, Lordship clearly says that discretion has to be exercised, my lord, for the in the light of the judicious mind. My question is that, my lord, if suppose I would have been, my lord, pleaded that I have been informed, despite of that, I failed to suppose file second appeal, my lord. My lord, I do not have any case at all. Now, Lordship kindly see that second ground Lordship has mentioned about balance the equities, my lord. I should not be deprived from getting justice, my lord. If suppose this burden would be overcome, my lord. My lord, second appeal may be hard. And second appeal, Lordship kindly, two very low points are involved. First thing is that, my lord, the learned court below exercise the original jurisdiction made a one observation that the burden of proof, my lord, 103 Evidence Act.
We are not going to the merits of the case. You concentrate your argument on the delay.
Right, anyway, my lord, balance of equity demands, my lord, equity says what? My lord, that justice should not be denied, my lord. And my lord, if denied, there must be exceptional situation. Here is a case, my lord, suppose
equity involves your conduct.
Absolutely, quite right.
If you're exercising equitable jurisdiction, your conduct is of primary importance for us.
My lord,
because you are the one who has approached the court.
Absolutely, quite right, my lord. My lord, my intention must be tested, my lord, in all parameters. If suppose my intention, my lord, if my lord, lessons and negligences are there, or malafide is there, or I suppose sitting silent over the issue deliberately, my lord. Absolutely, I do not have any right to suppose claim any, my lord, grace from this honorable court. But here is the case, my lord. I have pleaded and repeatedly I am saying, my lord, I have been deprived from getting one of the, my lord, very important legal advice that instead of revision, either or at that point of time, I have to prepare a second appeal, my lord. That knowledge never came in my notice, my lord.
So that part would be relevant for the period from 2013
revision to, my lord,
to 2018.
My lord, the period will 2000 from 16, my lord, because review
No,
was
it's giving from 13.
my lord.
Not of 13 to
Quite.
2018. From 2018 to 2021.
My lord, absolutely.
What is your explanation?
I have explained, my lord, in my lord petition that 2018, while it was withdrawn, that point of time, the learned counsel who engaged that point of time never advised me that now, instead of revision, a second appeal has to be preferred. Therefore, my lord, if suppose that suggestion was not rendered to me, my lord, how could I know that instead of revision, a second appeal is maintainable, my lord? Once this advice came to my notice in 2021, immediately I preferred second appeal, my lord. So that gap period, my lord, kindly.
If you read the order at page 83, 18/12/2018 order.
My lord. Mr. P. Dekar, the learned counsel for the petition, also had Mr. Chaudhary, the learned senior counsel assisted by Mr. M.K. Mishra, the learned counsel for the Dekar.
Mr. Dekar sought for withdrawal of this revision petition.
Absolutely.
Withdrawal will be done by the council without instructions.
My lord,
Number one.
Become
Number one.
My lord.
If it is done without instructions, what steps did you take against the
My lord,
council?
no doubt, my lord.
It has to be done with your instructions.
My lord,
If you have instructed to withdraw this revision, fully knowing that you have come for a wrong forum, thereafter you sat tight for 2 more years.
My
After that, do you think that you
my lord,
should be
both,
given?
my lord, both sides can be argued, my lord. There is no problem that what action we have taken care of, what, but ultimately there is a vacuum, my lord.
No, a revision or any case would not be withdrawn unless there is instruction.
My lord, normally what happened, my lord, that
Once it is
sometimes
withdrawn without instructions, to your risk, you have to take action.
Lordship, Lordship, quite right. We can put a lot of, my lord, questions on that issue, that because if suppose I do not have instruction, why suppose land council withdraw? But sometimes, my lord, Lordship also knew that sometimes the suggestion come later on, suppose withdrawal has been made and thereafter it has been intimated that the.
Have you stated anywhere that this withdrawal was made without your instruction.
My lord, we have not,
Then-
my
Even in
lord,
this petition, at this stage,
my lord, fair submission, my lord.
Yes.
Fair submission is that if we take into consideration, even withdrawal was made with my instruction, lordship presume for a moment, my lord. But if that point of time, my lord, if I would have not been rendered any suggestion, that now instead of that, a second appeal has to be preferred, my lord. Suppose if I argue in a different way, my lord. Suppose I asked the learned counsel and he didn't respond anything that second appeal otherwise maintainable or to be filed, whatever, my lord. But lordship, whenever,
Kamala, these are very difficult to digest.
absolutely, my lord, is a very complex.
Acceptance is something else, even to digest. It-
My- I
because
understood
these are all
myself.
frivolous kind of
Quite
arguments.
right,
you are
my
making
lord.
for this court.
I will not argue on
You
that.
try to make out some substantial point, we'll
My lord.
may accept. But
Lordship,
you
I-
withdraw at 18 and you come to the court in 21.
My lord, kindly sometimes, lordship, kindly consider
And
one
if
aspect.
it was displaced on marriage, council did not inform you, then also matter would have been different. Withdrawal obviously means that there was prior consent from your part.
My lord, that
And
thing
you
is that-
say that you are in litigation for the last 20 years
Yes, my lord.
and you don't know about the intricacies of law.
Lordship, that is the
Maybe
point.
you know better than your lawyer.
Lordship, can you see that I am fighting for my lord rights since 2004? And my lord, will
Very-
it possible that my
Very
lord,
difficult case. Yes,
my lord, close judgment, lordship permission?
yes.
Now, this is one of the judgment and another citation, lordship, I would like to rely upon. Lordship, can you see for a moment? This is recent judgments 13/7/2023. And lordship, here it is stated in the same language as lordship has already decided, paragraph, my lord.
What is the citation?
My lord, this is the citations of Supreme Court Delhi Development Authority. This month it was rendered 13/7/2023.
Is it reported?
No, my lord.
Give the civil appeal number.
My lord.
Civil appeal number. Civil appeal number.
Yes, civil appeal number, lordship, page 10, my lord.
You've given here.
Yes, yes. my lord. Page 10, my lord. Delhi Development Authority versus Jagan Singh. My age also inordinate delay 1,231 days.
Delhi Development DDA.
My lord. Now, paragraph 12, my lord. Page 13.
Judgment dated 13/7.
Yes, paragraph 12. Over the years, this court has repeatedly held that the liberal and justice-oriented approach need to be adopted in the matters of condonation below so that the substantial right of the parties are not defeated only on the ground of delay. The power on the Section 5 of the Limitation Act must be exercised in a very meaningful manner which will serve the ends of justice. 13. It is true that the fact that the decision on which the this is the ultimate finding that has been, my lord. But question is that, the same thing has been repeated, lordship, decided in 2021. So therefore, my ends of justice demanded I should be, my lord, allowed to suppose.
You have read which paragraph?
My lord, paragraph 12, my lord.
12, over the years. Okay.
And prior to the paragraph 11, my lord, 11, 12, I am relying upon, my lord. Paragraph 11 and 12.
Right.
Now, lordship, another citation, my lord, only last. Page 15. N. Balakrishna. Page 15. N. Balakrishnan, paragraph 10 and 13.
98, 7, 120.
10, 12 and 13, my lord, paragraph.
10, 12, 13.
My lord. Page 17, my lord. May I read, my lord, for a moment? Only one line is important here. Otherwise, the other thing are similar. Paragraph 10 says, the reason for such a different stance is thus, the primary function of a court is to adjudicate the dispute between the parties and to advance substantial justice. Now, the dispute, my lord, that has been cropped up, that has to be disposed of. Time limit fixed for the approaching the court in different situation is not because on the expiry of such time as bad cause would transform into a good cause. Paragraph 12, a court knows that the refusal to condone the delay would result in foreclosing a suitor from putting forth his cause. There is no presumption that delay in approaching the court is always deliberate. This court has held that the word sufficient cause under Section 5 of the limitations should receive a liberal construction so as to advance substantial justice. That is the one of the judgment that is relied upon. 13 is important, my lord. It must be
You have not
remembered.
read 11. 11 is also very important.
11, my lord. Rule of limitation are not meant to destroy the right of party. They are meant to see that the party do not resort to dilatory practice but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by reason of legal injury. Law of limitation fix a lifespan for such legal remedy for the redress of the legal injury so suffered. Time is precious and the waste time would never revisit. During efflux of time, numerous causes would spout up, necessitating newer persons to seek legal remedy by approaching this court. So a lifespan must be fixed for each remedy. Unending period for launching the remedy may lead to unending uncertainty and consequent anarchy. Law of limitation is thus founded on public policy. It is ensuing in the maximum interest republicae. You said finish mum. It is for the general welfare that a period to put to litigation. Rules of limitation are not meant to destroy the right of the parties. They are meant to see that parties do not resort to dilatory tactics but to seek their remedy promptly. The idea is that every legal remedy must be kept alive for a legislatively fixed period of time. Paragraph 12. A court knows that a refusal to condone the delay would result in foreclosing a suitor from putting forth his cause. There is no presumption that delay in approaching the court is always deliberate. This court has held that the word sufficient cause under Section 5 of the Limitation Act should receive a liberal construction so as to advance substantial justice. Paragraph 13. It must be remembered that in every case of delay, there can be some lapse on the part of the litigant concerned. That alone is not good enough to turn down his plea and to shut the door against. If the explanation does not smack of mala fide or it is not put forth as a part of dilatory strategy, the court must show utmost consideration to suitor, but when there is a reasonable ground to think that the delay was occasioned by the party deliberately to gain time, then the court should lean against acceptance of the explanation. While condoning delay, the court should not forget the opposite party altogether. It must be borne in mind that it is a loser and who would have incurred quite a large litigation expenses. It would be a statutory guidelines that when court condone the delay due to lessons on the part of the applicant, the court shall compensate the opposite party for his loss money. But we are ready to pay my lord, suppose that has been my lord. But question is that lordship, only one test is important, my lord. If they prove anywhere that after revision I have been advised on and I suppose not prepared, my lord, absolutely I am responsible, my lord. If suppose somebody sometimes appeal prefers, sometimes revision prefer because of wrong advice, suppose wrong approach, this kind of situation sometimes happen. And second appeal lordship is a very it's a serious round of litigation, my lord. Even my lord, that point of view, suppose the learned counsel would have preferred second appeal, my lord. No situation arises, my lord, to suppose.
What was the suit for?
Suit for my lord, my adopted status was put under challenge.
So yes.
And my lord, interesting thing is that my lord, I deprived from my lord filing my evidence due to the my lord some mistakes committed by the mistake, whatever. Then lordship, the important law point is very. If lordship just permit only 2 points, my lord. My lord, here in absence of leading evidence by the defendant, whether this suit can be treated as a contested suit or ex parte suit, my lord. I have a citation where says, my lord, it is a ex parte suit, my lord. It's not an intra-party dispute, my lord. And second point, my lord, that learned court below his original exercise jurisdiction shifted the burden to me, my lord. That I have to prove that I am the adopted son. Litigation has been prepared by the other side. They have to prove that I am not the supposed adoption, whatever, my lord. That's burden, shifting of burden, my lord, honest shifting, my lord, lordship knows well how it has to be, my lord, played its role.
Yes. Anything on the delay part? More? No.
My lord?
Anything more?
My lord, so explanation I have given, my lord, in my paragraph of the petition, my lord. There are 14, 15, 16 is the reasons, my lord. I have assigned.
14, 15.
There are 14, 15, and 16. Now, the singular test is that, my lord, my knowledge, my lord. They may say so many things, my lord, that delivered everything, but thing is that, my lord, if knowledge is there and I'm sitting silent, my lord, I don't have any right, my lord.
Then suddenly, how did you wake up?
My lord, because, my lord, what happened? They also, by delayed this matter on the basis of the judgment pronounced by the, my lord, appellate forum, dismissal, they approached before the deputy commissioner, my lord, where, my lord, I have obtained a next to kin certificate.
Now that we have understood. Then suddenly, how did you come to know that you have a right to prefer an appeal?
Because, my lord, This matter, once that has been, my lord, noticed by the deputy commissioner, they approached before me, my lord. Then I examined this all documents, then I came to know that actually this has to be preferred second appeal, my lord. But second appeal was not preferred, my lord.
Finding it very difficult. Yes.
Lordship, Lordship, to claim the benefit of section 14, due diligence and bona fide is important, Lordship. He is talking about knowledge, Lordship. The review petition was filed on 28/5/2014.
Yes. 28.
5/2014.
What has happened? 28.
14,
What happened?
2014.
What happened on that?
It was filed,
What?
review petition.
Okay.
Review petition was filed. There was a delay of 393 days
In the review.
review. So it was accompanied by a section 5 application. Their petitioner adduced evidence. I filed affidavit in opposition.
He adduced evidence.
He adduced evidence to explain the delay.
Okay.
Page 17 of my affidavit in opposition. From the kindly take it. Page 17 is stats. Lordship may kindly come to page 19.
You are Jagjit Singh Chetri.
Jagjit Singh.
Sukanya Khan is with you.
Yes, you are.
Page
19, paragraph 7. It is his affidavit part. And in cross examination also I told.
Page 19, paragraph
7.
This is a part of what?
Was a part of his evidence. Evidence in review petition. Mixed J case number 31/2014.
Oh.
It is the
Yes, yes.
application under section 5.
Evidence. Yes, what has happened?
She stated, on coming to Nagaon, my advocate suggested that the only remedy available against the said impugned judgment was in Guwahati High Court by way of filing second appeal. I came back to Guwahati along with file, and on coming back, took opinion from several legal practitioners and ultimately approached the present set of counsels. I showed whatever documents we had along with the file which was taken from the advocate at Nagaon. After perusal of the case at length, the present set of counsel informed that there are very limited grounds for second appeal for determining substantial question of law. As a defendant side did not adduce any evidence at the trial stage, but on my several requests, the present set of counsels wanted to peruse the order sheets of the title suit, as it was evident that there was no evidence from the defendant side. On perusal of the order sheets and other material by the present counsels, I was informed the scope of second appeal was limited. So in his affidavit itself, he said that he has the knowledge of second appeal, only ground is limited. And in cross-examination, also, he admitted these things. He stated that I have consulted with advocate Pinak Deka, High Court, Honiram Bora, Naga Court, and he suggested me to file second appeal. In cross-examination, page 23, last part.
Page 20.
Page 23. Even in page 22 also, it starts from page 22. Everywhere he stated his counsel advised him to file second appeal. Last part, it is clear. I have consulted with advocate Pinak Deka, High Court, Honiram Bora, Naga Court, and he suggested me to file second appeal in High Court. So
He knew in 2015 itself.
yes. So plea of section
This was
14.
recorded in 2015.
Plea of section 50, section 14 is not tenable at all. There is this good faith and due diligence is absent here.
When was this verification done? The chief evidence?
29/7/2015.
2015, 6th of May 15.
Affidavit was earlier. Yeah, his affidavit 6 May 2015. And cross was on 29/7/2015. Now,
Yes.
in this application lordship, that the delay of 393 days in filing the review application because it was rejected. So in this application, this part was also to be explained. It has not been explained. This one part. Then even if, as I have submitted, section 14 is not applicable, the filing of CRP and withdrawal is not, this period also goes away. Thereafter also, lordship, CRP was filed with a delay of 182 days. That is also 182 days. This period is also not explained. CRP was withdrawn.
CRP, the delay was condoned or? Yes.
No, it was filed under 227. But that for this application, it is required because this is now CRP was withdrawn on 18/12/2018 and RSA was filed on 1/12/2021. This four was no explanation. So in view of section 5, sufficient cause, there is also, it is not meant to, this is not tenable there. It is a settled where there is inordinate delay, stricter approaches to be put. Even.
Something else?
That I can, I mean, you'll have to submit a judgment on this section 14 lordship. That due diligence and bona fide is required. Good faith. Within 25 SCC 449. Paragraph 10.
2020. 5 SCC
449.
Arifa Ben.
Arifa Ben. Patel.
Paragraph?
Paragraph 10. Section 14 has been reproduced. 10 and 12. Section 14 has been reproduced in thereafter. In the bottom of this page.
10 and 12.
10 and 12. In section paragraph 10 plus section 14, then last two lines. In terms of this section, the time spent by the applicant for prosecuting with the due diligence, other civil proceedings may be excluded if such proceedings are prosecuted in good faith in a court, which from defect of jurisdiction or other court is unable to entertain. And there are paragraph 12. Any person claiming benefit of section 14 of the Act can only claim exclusion of time of that period for which it had been prosecuting another remedy with due diligence and in good faith. My humble submission is in this case, it is said.
Lordship, only one counter, my lord.
Welcome.
I think.
Let him complete.
And regarding the stricter approach, it is settled. However,
Yes.
however, this Oriental aroma case, I am just
Citation?
citation lordship 2010 5 SCC 449. Paragraph 15.
Fifteen.
15.
Yes.
The expression sufficient cause employed in section 5 of the Limitation Act 1963 and similar other statute is elastic enough to enable the courts to apply the law in a meaningful manner which subserves the ends of justice. Although no hard and fast rule can be laid down in dealing with the applications for continuation of delay, this court has justifiably advocated adoption of a liberal approach in condoning the delay of short duration and a stricter approach where the delay is inordinate. In our case, it is the inordinate delay. So my humble submissions to this application is liable to be.
The summary, anything?
Only my lord, one point I would like to, Lordship, now my learned friend rightly pointed out in paragraph 7 of page 19 of their repeated reply, where it is, my lord, clearly stated that my advocate suggested the only remedy available against the said impugned judgment was in Guwahati High Court by filing second appeal. Now, if afterward, my lord, if suppose learned counsel file a revision petition, what a litigant can do, my lord? If suppose that point of time it would have been filed second appeal, my lord, problem doesn't, my lord, arise to that extent, my lord, now which we are facing, my lord. If suppose I have been suggested at that point, and after, my lord, suppose then.
Unfortunately, you have named the learned counsel in your cross-examination. And it is just this counsel who has preferred the revision.
My lord, no doubt, my lord.
Unfortunately.
My lord, no doubt. That is, also I accept.
And better not to expand on this.
Absolutely.
It will not be proper.
Absolutely. That's why, my lord, I'm not insisting on that, my lord. What I'm saying, my lord, that 2018 period, there are two components prior to 2018, my lord, there are so many up and downs. And after 2018, there is one, my lord.
There is no up and down, there is only down. Down and down.
Now, Lordship, about bona fide, my learned friend has cited citations about bona fide, my lord. Lordship, if suppose a citation was rendered to me and I people suppose take me that revision petition, my lord. Now, can it come within the doubt, circle of doubt that my bona fide has to be, my lord, I have to prove, my lord? It is not that kind of situation, my lord, because suppose something.
See, you're the petitioner, you have to be consistent with your stand. Your entire stand was that you have not been given proper advice. In the chief, not even to go to your cross-examination, in the chief, you have said that you have been advised that the proper forum is an RSA, but the scope is very limited.
Right.
And you are all along saying that
Right.
there was no advice. That
My lord, ultimately, my lord, the lawyer are the driver and we litigant the passenger, my lord. Where support driver brings, they have to move, my lord. My lord, kindly see that a peculiar situation. We can blame here and there, myself or their self, but question is that, my lord, only one thing is that Insup Justice demands that my second appeal has to be tested. Lordship, just give one opportunity next week, my lord, any date.
then the limitation act will go to a toss.
No, my lord, by
Why limitation is required?
by overcoming.
Whenever you want, you can come to the court at your own pleasure.
My lord, with all
your own
folded hand, my lord,
convenience.
my lord, this problem, my lord, is there, my lord, but lordship, if give us
Limitation is a
one,
substantive law.
lordship, quite right.
Apart from the fact that
But
procedural
justice demands, my lord,
substantive right across on the third party.
absolutely, but lordship only see from different parameters. Lordship, Supreme Court and lordship has decided what parameters are required. Lenient approach, deliberations, my lord, Insup
Lenient
Justice.
approach, everything, but where is your bona fide?
My lord, exactly, my lord. That is one of the point. Bona fide is where, my lord. My learned friend.
You have pointed out one decision of this court, duration, your bona fide, your conduct, everything appears to be against you.
My lord, lordship, if suppose little bit lordship see in different angle, my lord, that if suppose
And the limit and the delay, how much?
my delay is, my lord, inordinate, my lord. There is no need, my lord, doubt to that effect, my lord.
How much is the delay?
My 2,475 days.
Only.
It is more than 7 years.
No, lordship, kindly see that lordship wants to test my bona fide from, if suppose lordship says that because I have been rendered in my lord, suggestion and therefore I preferred at my own instance of revision, my lord, instead
You
of.
have failed in your test of bona fide miserably.
Absolutely, man, but lordship, if I lordship put a question about my bona fide only counted instead of in spite of.
You have not even qualified.
Lordship, my humble praise that, man, at this moment.
Now let us pass the order.
My lord, if one opportunity will be given to us, my lord, we will pay, my lord, post to the other side for, my lord, whatever.
We have also considered that option.
My lord,
But you do not fall within that ambit. Unfortunately, we don't like to reject a petition under 5 normally.
There's a cogent effect, my lord. Can you see section 5 and 14 are there, my lord? Both are there. It is not only a case of my lord 5 or 14, my lord. My learned friend is insisting on only 14, my lord. There is a case, my lord, where I have projected that there are two situations, my lord. Prior to that litigation, after litigation, my lord.
Third. Three. Samaria. Is the item number?
26, man.
I. 2154. Third, P.S. Samaria Learned Counsel for the applicant, whereas P.S.D. Purkaster has appeared for the sole respondent. The instant application. The instant application has been filed for condonation of delay in preferring the second appeal against a judgment and order dated 30/4/2013 passed by the learned First Appellate Court in title appeal number 14 of 2011 by the aforesaid judgment, the appeal was dismissed and the judgment and decree dated 3/3/2011 passed by the learned Munsif number 2, Nagaon in PS number 96 of 2004 was affirmed. Para 3 Samaria, the learned counsel for the applicant has submitted that though the delay appears to be an inordinate one, there are cogent reasons which were beyond the control of the applicant from filing the appeal within time, and therefore the delay has been caused. Full stop. By referring to the documents annex, the learned counsel submits that there was wrong advice in continuing with the litigation after dismissal of the first appeal by the order dated 34/2013. Full stop. It is submitted that instead of an advice to file a regular second appeal, a review was advised to be filed, which was ultimately done, and the review was also dismissed on 31/3/2016. Full stop. Thereafter, a revision was preferred in this court, which was also dismissed on withdrawal by order dated 18/12/2018, and it was only thereafter that the present appeal has been preferred. In the meantime, there has been the delay. Full stop. The learned counsel submits that the suit was against the applicant, whereby another deed of adoption was put to challenge.
Lordship, so there is no deed of adoption. It is for a declaration that he is not the adopted son of.
Suit was filed for a declaration that the defendant was not the adopted son
Jugendralal
of
Singh Chitri.
the brother of the plaintiff. Full stop. It is further submitted that only recently, when a legal aid certificate, when an issue arose regarding application of a legal aid certificate, the effect of the state decree was reflected, and thereafter the present appeal has been filed. The learned counsel has specifically submitted that at no point of time, any suggestion was given to file the present appeal after the withdrawal of the revision. Also, it is also submitted that the applicant did not have the legal knowledge regarding the availability to prefer a second appeal, and only after certain exercise of due diligence, the present advice has been given. It is also submitted that there are good grounds of appeal, and the same should be heard on merit after condoning the delay. Full stop. In support of his submission, Sri Chamaria, the learned counsel for the applicant, has relied upon the following decisions. Full stop. 1, 2, 3. Number 1, Usha Roy, reported in 2022, 1 GLP 707. Number 2, judgment dated 13/7/2023 of the Honorable Supreme Court in civil appeal number 4335/2023, within bracket Delhi Development Authority versus ... Number 3, and Balakrishna versus so-and-so, reported in 1998, 7 SC 123. Full stop. Para. In the case of Usha Roy, this court in paragraph 18 has broadly laid down certain factors which are to be taken into consideration while considering an application for condonation of delay. Full stop. The aforesaid paragraph is extracted here in below. Full stop. Para. The Honorable Supreme Court, in the case of Delhi Development Authority, has laid down that a liberal and justice-oriented approach is required to be adopted in matters of condemnation of delay, so that substantive rights of the parties are not defeated on the ground of delay. It has further been laid down that there cannot be any hard and fast rule to decide whether sufficient cause exists, and everything depends on the facts and circumstances of each case. Also, in the case of N. Balakrishna, the Honorable Supreme Court, while reiterating the aforesaid proposition, has also provided the option to compensate the opposite party for the loss in the event such delay is controlled. The learned counsel for the petitioner accordingly submits that the delay may be controlled and the appeal be listed and the appeal be considered on merit. Per contrast, Sri S.D. Purkash, learned counsel for the respondent, submit that the length of the delay itself, which is 2475 days in an proceeding which is inter parte, is sufficient to dismiss the present case without even going into any other detail. Full stop. He submits that at each and every step, there has been delay which demonstrates utter negligence and negligence on the part of the petitioner in pursuing legal remedies. Full stop. It is submitted that the review against the order dated 30/4/2013 passed by the First Appellate Court was filed on 28/5/2014, which was itself delayed by about 393 days. And accordingly, an application under Section 5 of the Limitation Act was filed for condonation of the said delay. In the said proceeding, evidence was adduced by the petitioner, and the Purkash submits that the statements which were made would be very relevant for adjudication of the present case, as the same would reflect the inconsistent stance of the petition. Also, attention of this court has been drawn to the affidavit in opposition filed by the opposite party, filed by the respondent on 23/5/2022, in which the evidence on affidavit of the petitioner as well as the cross-examination have been annexed. Full stop. In the chief examination, which was filed on 6/5/2015, in paragraph 7, it has been categorically stated that the petitioner was informed about the scope of the second appeal, which, however, was stated to be limited Full stop. Reference has also been made to the cross-examination made by the petitioner on 29/9/2015, in which the following statement has been made. A page of- Green flag, huh? Is 20. wrong.
Dated Lordship 29/7.
29/7 we have said. 29/7/15 we have said. Question or 29/7? Cross-examination. Full stop. With para. As regards the arguments advanced on the applicability of section 14 of the Limitation Act, comma, the broadcaster, the Lieutenant Counsel, submits that there is no automatic application of section 14 as the exclusion of time would be allowed when a proceeding has been instituted bona fide in a court without jurisdiction. This happens that neither the review application filed against the order dated, judgment dated 30/4/2013 of the first appellate court was without jurisdiction, nor the subsequent revision filed in this court against the order passed in the review was filed in this court which had no jurisdiction. Full stop. He accordingly submits that the conditions precedent in section 14 being apparently absent, comma, the petitioner shall not get any benefit of the state thing. Full stop. Para. It is further submitted that the present RSA has been presented along with the delay condemnation application only on 1/12/2021, and there is no explanation, comma, whatsoever from date of withdrawal of the revision petition, which was on 18/12/2018, till the date of filing this appeal. Full stop. Sarah. In support of his submission, comma, the forecaster places reliance upon the following case law. Number 1, 2010 5 SC 449. Oriental Aromatic Club. Number 2, 2020 5 SC 445 449 4445 and 2025 SCC 449. Arifa Ben AARIFABEN versus President. In the case of Oriental Aroma, comma, the Honorable Supreme Court in paragraph 15 has held that when the delay is inordinate, comma, a stricter approach is required. Para. In the case of Arifa Ben, comma, the Honorable Supreme Court has explained under what conditions the benefit of section 14 would be applicable. Para. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. The suit was instituted in the year 2004, in which the judgment was passed in the year 2011. Full stop. The judgment by the first appellate court was also rendered in the year 2013. Full stop. The petitioner thereafter chose to file a review petition against the judgment of the first appellate court, which is permissible under the law, and the state review was dismissed on 31/3/2016. Full stop. Against the order passed in the review petition, a revision was filed, which was also dismissed on withdrawal on 18/12/2018. Full stop. Both the aforesaid filing of review petition and the revision petition cannot be said to have been filed in a court without jurisdiction, and therefore this court is of the opinion that the preconditions for applicability of section 14 of the Limitation Act shall not be applicable. This court is therefore required to examine this matter from the point of view of the delay. The delay in this case is admittedly of 2475 days. Full stop. There is no manner of doubt that the delay is an inaudited one, and therefore it is natural that the explanation to condone this delay has to be genuine, bona fide, and sufficient, so as to convince this court to condone the same. Full stop. The grounds projected were mainly twofold. Firstly, that no suggestion was given to file appeal after the revision was withdrawn, and secondly, lack of legal knowledge to prefer the second appeal. Full stop. The learned counsel for the applicant has also strenuously argued that a rebellious approach be taken, and so that substantial justice can be done between the parties. Full stop. Both the aforesaid grounds appears to be clearly inconsistent. Full stop. This court, as recorded above, has gone through the examination in chief as well as the cross-examination of the petition in the review proceeding before the first appellate court, which was in the year 2015. And there is a clear statement that the petitioner was aware of the provision of filing a second appeal, which second appeal. Full stop. It is a different matter that the opinion of the advocate was also recorded regarding the limited scope. Full stop. The scope of an appeal being limited cannot mean that the petitioner was not in a position to prefer such appeal. And in fact, the present appeal has ultimately been preferred by filing the same on 1/12/2021. Full stop. This court, in the aforesaid case of Usha Roy, has broadly laid out the conditions and factors to be taken into consideration while adjudicating an application for condemnation of delay. Full stop. The discretionary powers to be exercised by a court to condone delay has to be supported by the conduct of the petitioner who has paid for such condemnation. So such conduct has to be free from any negligence, free from lack of due diligence, and is necessarily required to be bona fide. Full stop. In the instant case, the inordinate delay, the delay of 2,475 days is itself inordinate and would not support the case of the petitioner that there was a bona fide approach. Full stop. The explanation given, as recorded above, are wholly insufficient. Full stop. This court also cannot be oblivious of the fact that by dismissal of the appeal, whereby the degree of the trial court has been affirmed, a valuable right has accrued upon the plaintiff, and that right cannot be taken away in a perfunctory manner. Full stop. This court has already held that the benefit of section 14 would not be applicable to the petitioner in the instant case. Under those facts and circumstances, this court is of the considered opinion that no case for condemnation of delay is made out, and accordingly the same stands rejected.
Deeply obliged.
Deeply obliged. Sorry.
Bad luck.
In this case, I'm appearing for respondent number 1, 2, 3, and 5. My lord, 4 has expired long back. My lord, I have also informed my lord.
The item number?
Yes,
You are for 1, 2, 3, and 5.
5, my lord. 4 expired long back. I have informed long back, my lord. There is an order to that effect, my lord.
Lordship, we need to file our substitution petition.
Is it still available to be filed, not abated?
Waited already, my lord.
You have to file setting aside abatement. What have you been doing? Your name, madam?
D Devi.
A. Devi.
D Devi.
Ms. D. Devi, learned counsel for the applicant. None heard Ms. D. Devi, learned counsel for the applicant. Also heard Sri P. Sundi, learned counsel for the respondent numbers 1, 2, 3, and 5. Also, Sri Sundi, the learned counsel, has submitted that he had earlier informed this court and also to the learned counsel for the applicant that the respondent number 4 had passed away. Until date, no steps for substitution have been taken. Full stop that. Ms. Devi, the learned counsel for the applicant, praised and is granted further 4 weeks time to take steps.
Obliged.
May please your lordship. Lordship, notices were issued on 13/6/2022. However, no service report has returned. But a report by the liquidator of the property has come, which has been placed on record, it shows that the land which was there, it has reverted back to the central government. The land actually belonged to a cooperative society. After rounds of litigation, it reverted back to the central government. Our only plea was that in an award of 8/2/1999, an award was given in our favor.
Award in which process?
Arbitration, you know.
Arbitration.
Arbitration award was given in our favor. Thereafter, in the year 2001, we had preferred, 2009, we had preferred the execution proceeding. Since then, it has been pending since long. They had preferred an objection, but the said objection was also dismissed by the court in the 2011. Since then, the matter has been lingering. The liquidator has also appeared before the learned.
How come the liquidator was been appointed?
Pardon?
How did the liquidator come into the picture?
The assets of the company, there was a winding up proceeding in a separate proceeding which is not connected to our case. Therefore, a liquidator was appointed.
No, you say it's a Samabaya Samiti, isn't it?
The Samavaya Samiti,
The Samabaya Samiti had gone into liquidation
liquidation.
and there is a liquidator.
Then a liquidator was
Now you
appointed.
say that the land which belonged to the Samiti has been given back to the central government.
Central government. All we say, Your Lordship, our very limited prayer in this revision petition was that the matter has been lingering since 2009 and the award is of 1999. So at least several times we have taken steps for issuance of writ, but no report was served back. Even the next date now fixes for submission of report.
Now, what is this CRP for?
This CRP, Your Lordship, with a limited prayer is for just directing the executing court for expediting the process because it has been pending since a long time.
Now, you see, have you, as it would appear from the report, the land has also gone back.
Land has also gone back, Your Lordship.
What relief will you ultimately get?
Your Lordship, the machinery and equipments perhaps are there because the liquidator long back.
Who are you?
I'm the decree holder in the executing proceeding.
It is the money suit. The arbitration was for money or what?
Arbitration of some money amount, which was around.
Now, who has not been served?
The respondents have not appeared.
Has they been served? Have they been served?
There is no report regarding that in the.
When was it issued?
It was issued on 13/6/2022, Your Lordship.
13/6. Today is 20. We'll do one thing. Unserved notice is not back.
Lordship.
Edit card unserved notice not back. We'll put this for Lozima. Let an order be passed from Dean Service, then perhaps we can proceed with it.
Very well, Your Lordship.
Priyan Chaudhary that conflict by referring to the office note dated 13/6/2022 has submitted that notices are issued to the sole respondent on 13/6/2020 and thereafter there is no subsequent note with regard to completion of service. He has also referred to a note dated 30/6/2023. Oh, this is of 13/6/2022.
22, Your Lordship, a year back.
Oh, you have to take press.
Press the-
He has also, we thought 2023. He has also referred to a note dated 36/2023 from the liquidators who has also sent a report in connection with the present proceeding. Let another attempt be made to serve the sole respondent, for which press steps are directed. Such steps are required to be taken by registered post within serves by Monday. List after 6 weeks. Okay, 6 weeks along with service report. If there is a similar service report, we will deem the service.
Highly obliged.
And you take instruction. You might need to implement the central government
Might be so, Your Lordship. I'll take.
and also take instructions what are the properties remaining on the plot of land are your dues would be able to be met by this property?
Very well.
Yes.
And then the matter may be taken up next week, Lordship. We need to take instruction.
What is the matter about review?
Lordship, they have preferred a review.
Review for
Review for an
A
order of
repetition.
this. No, Lordship, review for an order of this court, Lordship.
review in a repetition?
Yes, Lordship. It
This
is
court's order.
this court's order.
What was the order?
Lordship, they have, order is reflected that page 13. It
What was
start
it?
from page 14. There is
Medical
a
review.
periodical review. There is a direction to induct me in the Assam Rifles as a training constable and thereafter conduct a medical test. And there stand now, Lordship, that they prior to induct me in the force, they want to conduct a medical test.
Madam, that is not a ground for review. If you agree by the order, you can very well prefer an appeal. Review, the grounds are very limited. It has to be an error apparent. Our judgment may be erroneous. It has to be tested in the appropriate forum. Unless you can show that it is apparent on the face of it.
Lordship, my senior is in Lex, is coming.
Today, we are not going to pass any orders, but you come prepared next Wednesday. And this is a review pending since 2022. We don't like reviews to be pending next Wednesday. Prayer for adjournment has been made on behalf of MSA Gayan, Learned Council for Plans is appearing for the review applicant. Course of Sarah, considering that the review is pending since the year 2022, which has been preferred against judgment
Page
and
14.
order dated 22/6/2022. Please prepared, madam.
My lord,
And
one week time maybe.
Why?
My lord, I was out of session, I could not contact my lord. 1 week time, and next week, I have already informed
Let
them
us
to
pass the order today instead of 1 week later. Same order will pass.
same order. Same order.
The order which you are going to pass after 1 week, we are going to pass today. Any problem?
No problem. Excellent. I was out of session, I could not contact my lord, so that's why next week, my lord, Tuesday or Wednesday.
Even
my
if you contact, then also will pass the same
lord.
order.
No, I have already informed them to, my lord, comply the order of this my lord. I have already informed.
Very good. Come up with compliance, withdraw this review.
No, not withdraw my lord today. Not just, I have to take it.
Today you are not saying, you
Yes,
are not pass
yes,
orders,
yes,
you are
ma'am.
prejudice.
Yes.
MSA and Learned Council, submit that some development is on for which instructions are required to be taken.
Yes.
List on Friday next.
Yes,
workshop. It is however made clear that irrespective of the fact whether instructions are received or not, this court will proceed with the matter on the next.
Must comply.
much obliged.
Maybe, not office note, my lord. Two office note is there, my lord. One is 17/2023 and 4/7/23, my lord.
Yes.
My lord, pro forma respondent number 5 and 6 not located, my lord. So we have to take 3 steps regarding note 5 and 6.
No, if the addresses are not correct, you
Yes,
have
ma'am.
to take instruction.
We will take
You might
instruction.
require to publish paper publication.
We will try to collect, my lord.
You grant you some time. You try to have the addresses, proper address. Here for whom?
And my lord, 9, 11, 12 and 14 already expired, my lord. And for 1, 2.
So then you have to take steps for substitution.
And for 1, 2, 4, 6 to 9.
Item number. You are HR Ahmed.
Yes, my lord.
HR Ahmed Learned Council for the applicant by referring to the office note dated 1/7/2023 has submitted that respondent number 5 and pro forma respondent numbers 6, 9, 11, 12 and 14 could not be served.
No, 5 and 6 could not be subject.
No. Yes, you're correct. Submit that Respondent number 5 and pro forma respondent number 6 could not be served as adversely could not be located. So far as pro forma respondent numbers 9, 11, 12, and 14 are concerned, the state respondents have been stated to have been expired. The Learned Council accordingly also heard
PK
PK Porua Learned Council for the respondent numbers 1 to 4
and 6 to 9.
6 to 9. Islam is also there.
Is regarding my lord, 1A to 1N, my lord.
On the prayer of the Ahmed and counsel for the applicant list after 3 weeks to enable him to get the information of correct address as well as the legal error of the pro forma respondent 9, 11, 12, and 14.
Also, this is an application for condonation of delay, and the service is complete now, your lordship.
Somebody has appeared, you have appeared.
Yes,
All the respondents.
yes, sir.
Have you filed
For
your
respondent number 1 and
1 and 2? From where are you making submission the service is complete? Office note is there.
Office note, your lord.
Received. Found it.
Respondent 3 to 7, pro forma respondent.
Yes. They are pro forma respondents.
Yes, sir.
Uh, right, good. Your name?
J. Das, on behalf of SP lawyer.
Did as Learned Council by referring to the office note dated 13/7/2023 has submitted that service upon respondent numbers 3, 4, 5, 6, and 7 may be deemed to be complete as the notices have either been received by them personally or the relative. Madam, you for 1,
for 1 and 2.
your name?
D Devi.
Ms. D. Devi, Learned Council has appeared for the respondent numbers 1 and 2. Have you filed your objection
Yes, Lord.
and submit that the objection has already been filed in this petition for delay condonation?
Yes, your lordship.
We'll have it when? Wednesday next?
Yes, sir.
The application. As this service is complete, let this application be listed for orders. on
Next
Wednesday.
Friday, your lordship will do it.
Next Friday, okay, next Friday. Friday, madam,
Lordship, there will be some difficulty. My senior will be out of
tell us which is
Wednesday, Lord.
Wednesday, is it okay?
Wednesday,
How much is the delay?
772 2 days.
What is your explanation?
Your lordship.
Your explanation?
The file was misplaced due to the renovation, your lordship, and due to that's the main reason, your lordship.
Which file?
The case file. Still, there was some construction going on inside the our chamber, in our senior's chamber, and due to that,
How have you verified in the affidavit? Who has given the affidavit?
affidavit has been given by the appellant, your lordship. If you can fix the date, my senior will appear and do the satisfy your lordship.
Okay,
Lordship,
but you better you file an affidavit by the council. The client will not know what renovation was going on. If you are attributing fault upon yourself, there has been affidavit. 772 days is not, the delay is not small delay. You have to come with proper explanation. What is the appeal about?
It is for RSA, your lordship, against title appeal for in
Concurrent finding. Concurrent finding.
not concurrent finding, your lordship, and our appeal was dismissed, and we are the plaintiff. So
Plaintiff appeal was dismissed in concurrent findings. If you are the plaintiff, if you prefer the appeal,
Right,
it means
Your Lordship, right, and
difficult
Right.
on your part, come up with proper material. Yes, we'll have it when? Tell us, madam. When, Friday,
Lordship,
Well,
3rd of August.
3rd of August.
obliged.
Mr. Goswami is sitting for long, which matter? No, not you, your. Yes, next. 30? Next. 32.
Right, please, Lordship. Lordship, 280 days delay, Lordship. And service is complete, Lordship.
Appeal against what?
First appeal. Title appeal.
Yes. Talukdar for whom?
My Lord, I'm for. My Lord,
Filed your objection?
1, 2, my Lord, 1, 2.
Filed your objections or not?
No, my Lord, I filed Kalapama and.
You like to file objection?
Yes, my Lord, but Your Lordship may also heard, my Lord, maybe disposed today also, my Lord.
Other respondents?
He's appearing for.
I am for 3 and 4. Lordship.
How for?
3, 4,
3, 4 and
Three,
performer respondent Lordship
12, 13.
12, 13 and 17.
And there are SI Khan. Who is SI Khan? SI Khan is Mr. Talukdar.
Yes.
And okay. You do not have any objection?
I have objection, my Lord. I'll make submission, my Lord.
Now, if you are not having serious objection, we'll record your objection and delay, condone the delay.
My Lord, objection is that there is about 3 years late,
Then
my
you have
Lord.
to file an objection. Oral objection will not be sufficient.
All right.
Huh?
Yes.
If you are not having any objection as a counsel for the delay, then we'll record your objection and condone the delay.
Maybe-
Otherwise, if you have serious objection, you have to file it on record.
Submission may be recorded.
Submission may be recorded, my
You don't want to do some exercise.
Lord. I'll go and
The court will do the exercise for you. Well, very well. Yes, what is your name?
SRA Nasir, Lordship.
At your number?
32.
SI?
SRA Nasir.
Where is your name?
I'm on behalf of Zialom. And my name has not been reflected. This is filed by me, Lordship.
Your name is there in the Wakalatnama.
Lordship.
Is your name there in the Wakalatnama? Can you record your name directly? Or yes, your name is there. Why is Wakalatnama? No, Wakalatnama. You're not a member of our bar.
Lordship. No.
Very bad. Why don't you become a member of the bar? What is the
I am applying, Lordship.
should be members? Heard SRA Nasrin.
Nasir.
Nasir.
Lordship.
The counsel for the applicants who by means of this petition filed under section 5 of the Limitation Act read with order 41 rule 3A of the CPC has paid for condonation of delay of 218 days in preferring the appeal against the judgment and decree dated so and so asylum. Filed in a title appeal affirming to it. Huh? Where are your averments?
Lordship.
Averments grounds.
Lordship in para 4.
The learned counsel has drawn the attention of this court to the averments made in paragraph 4 and has submitted that there were sufficient reasons which had prevented the applicant prepare the appeal in time, and such reasons were beyond the control. Also, he further submit that there is no lack of due diligence. Also, but on the other hand, Sri A.K. Talukdar, Senate Council for the respondent numbers 1, 2, 10, 11, 14, and 16, as well as Sri A.B.T. Hawk, Senate Council for
3, 4, 12, 13, and 17.
3, 4, 12, 13, and 17. Submit that the delay is an inordinate one, and the reasons put forward are not sufficient.
My lord, one point may I point out, my lord. The entire explanation is given only about number 1. There are 20, my lord, appellants, my lord. There is no explanation about anyone else. Why they did not, my
It
lord.
is further submitted that the explanation pertains only to applicant number 1, and there is no explanation whatsoever with regard to the rest of the 19 applicants. Yes, what do you say? The tribal submissions have been duly considered. Also, the explanation given in paragraph 4 explanations have been perused, and it has been stated that it was the applicant number 1 who was taking steps and had fallen sick for a long period of time. Also, therefore, the objection that there is no explanation for all the applicants may not be sustained. At the same time, this court has seen that the delay is not a meager delay, but of 218 days. The Honorable Supreme Court has laid down the law that in consideration of an application for condonation of delay, a pragmatic and justice-oriented approach is to be taken. At the same time, the valuable rights which have accrued upon the decree holder cannot be decree holder, on the opposite party cannot be overlooked in a overlooked. Therefore, balancing the equities, this court is of the opinion that the delay of 208 days may be countered for subject payment of cost of rupees 2,000. Accordingly, it is directed, accordingly, the delay stands condoned, subject to the payment of cost as indicated.
My lord, whom to be paid, my lord? To whom to be paid? Perhaps the legal service.
You tell us the cost is to be paid in the name to the Guwahati High Court Lawyers Benevolent Fund.
Highly obliged.
Take the benefit, be a member.
Lordship, I will enroll as
Okay.
for an apology. I will.
Okay. Next. Arculita and Portoloy. None appears for the applicant on call review. In the interest of justice, please Dr. Ravi.
May I please, Your Worship, the IA is for condoning delay of 84 days in filing the connected regular second appeal, Lordship.
Yes.
The
I have filed an objection on record, my lord.
Serious with the objection or we condemn the delay?
My lord, I'm serious, my lord, because in two aspects, my lord. First, they have said on medical ground, my lord, there's a delay. And
Who are you? Plaintiff?
I have plaintiff, Lordship.
It was
Concurrent
dismissed.
pending.
Concurrent for dismiss. Appeal dismiss.
Appeal.
The plaintiff suit was for?
It was for declaration of right most. Declaration of plaintiff's right, title and interest over the suit land, houses and premises as shown in the plain schedule. And confirmation of position in respect of the land. I mean position.
confirm.
There is confirmation of position, not recovery. We'll condemn the delay.
Cost, my lord. Because, my lord, on two aspects, my lord, I have filed this objection. They have-
We'll record your objection.
Yes, my lord. They blame the earlier council, my lord, without filing any objection.
Your ego high.
I am UB Sharma, Lordship.
You be sure, your name is not there, or is your name is?
On last occasion, I was A who has the Lordship.
It doesn't matter. Heard the UP Sharma donate counsel for the applicant. Also heard the Philadelphia learned counsel for the respondents 2 and 3. Who is for 1?
1 to 4. I am expect for all, my lord. 1 to 4.
For all the respondents.
1 to
This is an application. The applicant paragraph 2 दे दी, वहाँ 4 दो। Which paragraph?
Lordship, in paragraph
3.
number 3.
Paragraph 4 था, it's 3 थी, हाँ? The applicant was the plaintiff in title suit number 234 of 2014,
Yes.
which was dismissed, and the first appeal number and the RFA number
Not RFL, Lordship. It
is
was
RFL.
title appeal.
sorry, the title appeal
26 of
26
2018.
2018 was also dismissed. How much is the delay?
84 days, Lordship.
298. To EPT for yes, we paid 2,000 cost. Delay will be confirmed in the name of the High Court Venezuelan Park.
Earlier,
One
please.
one more thing, my lord, in the appeal, my lord, that has to be numbered. The name of, my name should be reflected.
In the
Otherwise-
appeal, you write, in both the cases you write, huh? In that case also. The delay being condoned by an order passed today, that is to let the appeal be registered and listed for admission in due course. And इसमें देखिए appeal में ये वाला let the names of the counsel for the parties be reflected in the court.
So what happened, my lord, when the
don't know, my
delay was there, my lord? When delay was disposed of and appeal, my lord, the respondent name has not been shown, my lord. In a very much case, my lord, earlier, my lord, I think that The name of the respondent hasn't been shown by the system. And that's
This-
why
This is an issue, but what has happened is on on disposal of the IA, the Wakalat number has been filed in the IA.
yes, sir.
The office normally considers to be Wakalat number only for the IA purpose, which perhaps is not a correct approach. So we can correct
Yeah.
that, that's not a problem.
That is the issue, my lord, that is the issue going on.
Yes.
Highly obliged. Obliged.
Okay, sir. Thank you. Thank you.
There are IAs for substitution of legal heirs of respondent number one. And there is an application for condonation of delay in filing the substitution application. Then there is one more application for setting aside the abatement as well as delay in preparing the application. But before I'm starting, I would like to inform the advocate for the respondent number one, Mr. H.L. Moria. He called yesterday and said that he is not well, to inform the court that.
We'll have it on a date fixed.
Yes, Lordship.
Whenever, Wednesday?
Any date, it was 1 week, he said, no, he will not be able to come for 1 week, he said that
We'll
he's
fix the
not
date
unwell
after.
after a week.
MS Steve Burgoyne and counsel for the applicant in these cases submit that he was telephonically informed by the H.L. Moria, learned counsel for the opposite party, that he is not well. Full stop. In view of the same, also heard K.K. Bhattacharya,
Respondents 2 and 3.
the state council, as a state
respondent.
as the third state council, the interest of the list these cases after a week.
After. Obliged.
May it please your lord.
Yes.
My lord, the IA has been filed by the son of the respondent, deceased respondent number 1B. I am for the appellant. I've been newly engaged in the matter. I am for the appellant. And this IA 3462 is filed by the son of the deceased respondent number 1B, Jamshed Ali.
For his substitution.
My lord.
Who is representing?
I'm appealing for the respondent.
Have you filed the IA? IA is by you
We have filed.
for substitution. Is it within time?
Two of the respondents. have
My
both
lord.
died in the-
My lord, the date is, my lord, of 2016, but after the appeal was admitted, thereafter the matter has not come, my lord. So neither they informed us or we came to know about his death, my lord. Let it be allowed, my lord.
Heard. Sri K. Gupta, Senate counsel for the applicants, two numbers
Two numbers.
for the applicants to have filed this application for their substitution. Where, two numbers are
Jamshed
one.
Ali.
No, Jamshed will be,
Jamshed Ali is represented by Firoz Ali, who is the applicant of IA number 3462 of 2022.
there is one applicant.
One number.
My lord, there's another IA, my lord. I'll come to that, my lord. This
Then
IA
that is not
3462.
Yes.
3462 applicant is Firoz Ali, son of deceased respondent number 1B, Jamshed Ali.
There is one applicant.
Yes, one.
One applicant.
That's it. Here is one applicant, in other application, there are two applicants.
Go one by one,
One by
otherwise the court.
3497 is which case?
3497, my lord, if your lordship would see the clause title of the RSA,
3497 is for us or not?
yes, 3497 is there, my lord.
Item number?
Item number 36. It is not shown in the list, my lord. But the IA is pending. IA is pending, my lord.
Okay.
For that,
Amjad Ali had passed away.
my lord, yes. For that, my lord, my submission is that, my lord, if your lordship would kindly peruse the cause title of the RSA, his legal heirs were already substituted, wide order dated 17/12/2012, passed in MC number.
We'll do one thing.
Yes,
We'll pass orders in 3, 4, 6 today,
my
and
lord,
we'll consider the other one later.
my lord.
If you say that they're already on record, the necessity of their substitution may not arise now.
Correct, man. Absolutely.
But Gupta Leonard Counsel for the applicant, who by means of this application has prayed for substitution of the respondent number
One,
considerably was number
1B,
respondent number 1B.
D, yes.
Why won't be considerably was number 2?
My lord, original respondent was Iman Ali. When he expired, his sons came in. Jamshed Ali is 1B. my lord.
Okay, for substitution of the respondent number 1B, Jamshed Ali, who has passed away during the pendency of this proceeding. Sri Gupta, the learned counsel, has submitted that the applicant is the son of late Jamshed Ali and is required to be substituted as the right to sue survives. Also heard Sri J. Mukit, learned counsel for the opposite party appellant, who does not object in principle to the aforesaid prayer. In view of the above, the state IA is allowed and the substitution of Jamshed Ali of the respondent number 1, Jamshed 1B, Jamshed Ali is to be made by the present applicant, Sri Firuz Ali. Also, I, according to the disposal, in the main appeal, you write, in view of the order passed today, that is in IA 3462/2022, comma, the name of the respondent number 1B is to be substituted by Sri Firuz Ali, son of late Jamshed Ali.
My lord, the stay application is still pending and that interim order is continuing. Lord.
Is it limited by time?
No, my lord. It is continuing. That is MC number 3608/2000. Interim order may kindly be extended.
That is what it is. Is it bound by time?
No, it's not.
It's not bound by time.
My lord, it simply says to continue, my lord. No time, my lord. No time.
It's not till returnable date.
My lord. No.
And the second one, we'll have it on another day. Mr. Gupta. And if, also, Mr. Gupta, try to have that thing considered. If he says that it's already been recorded, they are on record, there is no requirement of further substitution.
I've also been newly engaged.
Last matter.
Lordship, I am appearing on behalf of Mr. B. Burahima Senior. Here in this case, Lordship, this IA is for condonation of delay, Lordship. 950 days delay.
950 days.
Yes, Lordship.
Sharma,
Not a single line that court can at least allow, not a single, just sitting idle, nothing has been done. No, not a single line in the petition, Lordship. That this is only the reason he could not come before the court.
let us see, madam, your reasons.
Yes, Lordship, in para 6, 7, and 8, some reasons that is the financial hardship of the petitioner. This is the main. He couldn't able to come to prefer an appeal, Lordship. The main case is for partition. And he is not allowed to stay in that disputed land, Lordship.
950 days,
Yes, Lordship.
difficult, madam.
And only reason is financial hardship. This is the only reason.
Difficult, we'll have it on another day. Today,
Lordship.
not today. Positive,
Wednesday, Lordship.
next Friday. Positive time did not permit the matter to be taken up. Correct? Yes, sir. Rest of the case. 50 days.
God bless, Lordship.
interim order, but that may be.
Interim order, wherever there are, we'll extend.
Fine.
I-
We'll give date, any case where interim order is still to date. Sharma, item number
43.
39.
Madam,
item number
45, there is an interim order.
Lordship, item number
44 also there.
40, 39,
44,
44,
yours is 30,
39.
39,
Lord, I,
44.
and
Madam, 44,
45.
I.
45. And
Mine is
number 60, my lord.
59.
interim order is there.
60, my lord.
Yes.
Yesterday I mentioned my lord for listening, listening today.
Is there
my
any
lord.
interim order?
60. No interim order is there.
No,
my
we,
lord,
they
my-
still give, only matters are 43.
43. there is
Interim order is
interim
there,
order.
43.
But there was some urgency, my lord, that is why it was listed today, but if it can be listed immediately Monday or like
Give it.
suitable date.